ready to go? Ready to go? Okay. Welcome everybody who's here. One of our members, Shelley, the judge is, I'm going to do this again. Let me try this. Still in court with her calendar, so she'll be running about 45 minutes late. But I want to welcome everybody else for being here in LA on this wonderful Wednesday, it is. I thought maybe we would go through and have everybody kind of explain who they are again. There are some new people here who weren't here at the last meeting. And so since Larry's getting coffee, I'll start with Ezra on the other side. We'll come to Larry last. Okay, Ezra, you want to explain who you are and we'll go forward?
Good morning, I'm Ezra Angelis. I'm the coordinator for volunteers. If you have any questions or you'd like to talk specifically, you can contact me. So raise your hand and I'll contact you after the meeting.
Okay, so that brings our first point up about the mic. So whenever you speak, we want to make sure the mic is on. And when your mic is on, the little red light will be on. And then when you don't want to be heard, you should turn the mic off. Okay.
Thank you, Jim. Donna Hershkowitz, I'm the Chief of Programs here at the State Bar of California. Welcome, everybody, and I apologize that I was unable to join you last time, and I am excited to be here today.
My name is Michael Glass, and I'm a supervising attorney with the Office of Chief Trial Counsel for the State Bar of California. And I have prosecuted through my career as a member of the Office of Chief Trial Counsel approximately 10 to 12 moral character cases, and I am honored to serve as part of this working group.
And good morning, everyone. I'm Mark Torres-Gill. I'm the Assistant Director of the Office of Admissions.
Good morning. I'm Amy Nunez, Director of the Office of Admissions.
And my name is James Efting. I'm the chair of this working group and trying to help us work together on this. Specifically, I'm an attorney licensed practice law. I practice in Santa Clara County as a trust and estates attorney. And more specifically to this particular group, I am the chair of the moral character subcommittee and do handle a number of the informal conferences in that regard.
Hi, my name's David Lane. I'm counsel for moral character determinations at the State Bar. And when the new rules are implemented that govern informal conferences, I will be conducting the informal conferences with applicants. Looking forward to that.
Good morning, I'm Tara Clark. I'm the program manager for Moral Character.
I'm Desti Overpeck. I'm with the Office of General Counsel for the State Bar.
Hi, I'm Caroline Holmes. I'm also with the Office of General Counsel for the State Bar.
I'm Patrick Piggott. I'm Dean of the Law School of Law at Humphreys University. And Ray.
Hi, I'm Debbie McCamal. I'm the Executive Director of the Stanford Criminal Justice Center at Stanford Law School.
I'm Meredith D'Angela, Dean of Students at University of San Diego School of Law.
Good morning, I'm Michael Clancy, Dean of Northwestern California University in Sacramento, California.
Larry Kaplan, I'm a public member of the Committee of Bar Examiners appointed by the Speaker of the California Assembly.
Thank you, everyone. So this is an open public meeting. It's being webcast in case people weren't aware of that already. So what you are doing is being watched or could potentially be watched by other people. Just let you be aware of that. And I was supposed to announce that was number 1A. We're now moving on to 1B, which is a call for public comment. Again, since this is a public meeting, if there's anybody from the public who wants to make a comment, this would be an opportunity for them to do so. And having seen no one, I'm going to assume that there is no public comment. We'll move on to 3A, which is the report of adverse moral character determinations by year, which Tara will start with.
So good morning, everyone. In the packet in front of you on top, you should have the document that we put together for you. I think Ezra is signing in to put it up on the screens right now. So at our last meeting, you had asked for some numbers regarding the number of negative determinations per year. Ezra, it's the adverse, it's not the PowerPoint. Let's see, give him one. Okay, so I think we had kind of mentioned it last time that we do have to calculate these numbers by hand. Unfortunately, our old system was unable to do it for us, so we went back to 2015 and counted the number of denials. Down at the bottom, we do have the total number of appeals of those that were denied. And then a couple of the outcomes, we weren't able to break it down completely due to confidentiality, but we just wanted to present this to the working group per the last request. So if there's any questions on this.
When you say denial, is that after all the appeals?
No, so this is a denial initially from the Committee of Bar Examiners, and then the appeal at the bottom where we said there are 36 appeals, these are the appeals to the hearing department. So we didn't break it down further than that. Mhm. Right.
So specifically, someone would have gone through the process of applying, would have asked for an informal conference, would have gotten the informal conference, then the Committee of Bar Examiners would have said, based on the totality of factors, we're going to deny this person admission to practice law. So that's what the number of denials would be.
Full year 2018. Does that mean both bar exams for that year,
So
or just a moral, they don't have that categorized? Yeah.
correct, this is just for moral character, so all of the moral character applicants, we only had 38 denials last year for 2018. And that's the number of total applications we had, correct?
Do we know anything more about the categories of those 38 people? Like what the denial was based upon and what category it's in?
So we weren't able to put that information together, unfortunately. I mean, it does range from a number of items, but we don't have that information right now, so.
Will you be able to give it somehow?
We'll have to consult with OGC to see if that's something we can provide or not. So what we had them do last time is we put the information together, they let us know whether or not we can provide it since it is public information, so we'll have to touch base with them and then see if we can provide it for the next meeting.
Yeah, the issue that we have is that this is confidential because it's part of their application. And so to the extent that details about why somebody was denied allows that person to become identified, that would be prohibited under our statute. So that's where we have to be very careful about
I don't see
what
how we
we
can
give.
do our job, talking about changing moral determination if we don't know what it is. I've had a student with a drunk driving denied. I've had a student who sold drugs denied. I have a student who did 2 prison terms denied. I mean, I can't find a pattern. I don't know what is the problem we're trying to direct. I'm sure 10 years ago it was different concepts. But today, is it any conviction? Is it just felony convictions? Is it alcohol?
So there's nothing that bars admission, so a conviction alone is not something that would bar it. We do take into consideration the factors, but we also do look at rehabilitation, the time since the incident, the age of the person at the incident. So it's a number of things. It's the totality of the situation. It's not just one incident.
If we don't know how they got into the system.
And today, hopefully, some of that will be clarified when we talk, we're going to begin today talking about some of the different categories, that could lead somebody to being denied. And while we can't talk about specific cases, we can at least, talk about, for example, the unauthorized practice of law and how that might come up in certain situations.
But let's talk a little bit more about this point and about sort of the level of detail that you think would be helpful, right? Are we, right, I can see us wanting to know, of the 38 denials in 2017, did every single one of those people have a felony conviction, right? So let's sort of talk about sort of how much more detail would be helpful, and sort of obviously from what Dusty's saying, sort of the more we drill down, the less likely it will be able to provide it. But certainly having some sense of what information would be helpful to make sure that we are that we are shaping the new guidelines going forward in a way that maybe prevents a situation that you think shouldn't be occurring that could be occurring today.
I want to say one of the guidelines that troubles me, the 2 felony convictions I mentioned should never be allowed to be a bar member. But he did come to law school, but I had him sign a document. I do not think you're going to go through morals check. You're not coming to school thinking you can. And that's the problem. I don't know. That's a big high level. What about more middle levels? They're going to spend $62,000 a year tuition now. We just looked up $101,000 for your expenses to Stanford a year. You spend $300,000 and be denied. Then there's some obligation you notify people. So deans have a guideline did it, and then the committee that evaluated, that's really good, but it should be something.
Yeah, well, and that's exactly what this process is about, because we want students who are applying to law school to be able to have a general sense, right? As Tara said, it's all totality of the circumstances, and so they're not gonna know for certain, will I have a positive moral character determination or not? But having sort of a general sense, and we want the deans of the law schools to be able, and their staff to be able to advise students. And the only way you can do that is if our guidelines are clearer.
Exactly.
And that's exactly why we're doing this. We know our guidelines need to be clearer, and we need to be more transparent as much as we can. You know, I had previously talked in the Committee of Bar Examiners about sort of the concept of, you know, doing decision matrices, right? And if you've got X and Y, now that's probably not going to work because there is so much sort of totality of the circumstances that goes in. And, you know, even if you do a decision matrix, you say, if you have X and Y, but you are, but there's candor and you understand the implications of what you've done, like it's still not totally objective, and it can't be totally objective. But I think we do want to dig into the extent to which we can do something like a decision matrix, the extent to which we can have some guidelines that give the deans and the even more importantly, the people who are thinking of applying to law school, greater clarity on whether or not this is a useful investment to them if their goal is to be admitted to the state bar.
And I think to Donna's point, so once we get into the PowerPoint again, as David mentioned, when we go through each topic, you'll see that we looked at California, what we say, what the other jurisdictions said, and there's not a ton of information about a lot of the things we look at. Maybe it's bullet pointed or briefly mentioned. So part of what we're doing is we're going to propose some language or like a description of what the unauthorized practice of law might be, what, trying to think, like abuse of the legal process, things that we might look at, so that way it is better guidelines for the students and for the law schools themselves, so.
I just want to make,
On the topic of this specific information, I would personally find it helpful as a member of the group to know, Donna, as you said, if it was a felony, if it was a misdemeanor, if it was multiple incidents, or if there was a categorization of moral turpitude. I think those would be high-level pieces of information that would be very helpful in terms of the denials. Or multiple incidents.
I just want to quickly add, on our, I get notices from the bar, this student is under, has been denied and there's an appeal, and we want to know, did they tell you they had this conviction? There's no requirement that I ask. Now, I do on our application, but there's no requirement that the law schools ask. Now you're saying maybe the student did something wrong for not telling the law school, then we need to think about some of these rules for the application process to make sure that if you're going to use it against them, it was in the application process.
Many of the times we do ask, but we look at what the law school required, because each law school application is different right now. So I think, Dean Pickett, you had sent some suggested questions, and so we were considering, I think, for next meeting, having the law schools as a general topic. But currently, the way the process works is that, you know, if we send out the law school declaration and it looks like maybe something that should have been disclosed wasn't disclosed, we'll ask for a copy of the application itself, and then we'll look at the specific wording, because some schools ask for just convictions, some ask for everything, including arrests or citations or detainment. So we try to base it specific to what that school says.
But
It's
you
not
see
just
what
a
you
general
said.
rule.
You used the term, should have been disclosed. Then shouldn't you have told us we should have asked?
Well, so it depends on what the school asks for. So we look at what the question said, and if, based on the question, if they should have disclosed it or not. We're not making that determination beforehand. We're just looking to see if they should have.
Donna, if I could add to the list that Meredith began, I might, if you could break it out for felony, violent versus nonviolent. I think that's number of applicants who have violent felony convictions are very curious about whether or not they should bother applying. And I know we're gonna get at it, Tara, like, but what are the other major categories of denial that we should be thinking about?
Yeah, I was gonna say
Like
that,
substance abuse, I mean, what are the other,
right.
I think it's more than just criminal convictions.
So maybe rather than asking you, I mean, if this is okay, rather than having you list out each topic, what we can do is we'll look through the high-level topics, and then as far as we can break it down with Dusty, because there are things like candor or omissions. You have fraud or discipline in another practice. There's a multitude of factors. It's not just criminal, like you said, so it's a lot of different things.
Yeah, I was going to say there'd be a number of things, financial issues, discipline in law school. I mean,
Honor code violations are another, and another piece of that, a big piece of that puzzle is, insight and rehabilitation as well. I mean, that's part of that, a significant part of that scale. I don't know with respect to, we'd have to look at this to determine whether or not we can somehow summarize the rehabilitation aspects of particular cases to give you some sense of what was involved without, of course, identifying, individuals, because that's a little more of a tricky area than just identifying broad categories of misconduct.
I'm wondering maybe if there's a time frame since the felony occurred or something like that, because I know that came up in the Stanford study. That might be something we might be able to group as well.
Also, don't forget that while state bar court cases are confidential and can't be disclosed publicly, Supreme Court cases are. So there's a number of Supreme Court cases that are out there. They go all the way back to, I think, around 1924, up to 2014, I believe, when the Enright Glass decision was approved. So, those Supreme Court decisions are also very helpful in providing guidance and a sense of what the Supreme Court looks for in these types of cases.
As we move on, if there are more topics you want to give to Donna, we're going to change subject slightly, but you add them on. Just say, oh, Donna, this came up later on. Can you add this to the list or add this to the list? Just keep building to get the information you need. Okay.
Thank you for pulling that data out of our
Moving on to 2B, discussion of attorney disciplinary cases addressing moral character and moral character related misconduct. I think Michael Glass is going to talk about this subject next.
Yes. One of the tasks I was asked to present at this meeting was which of the areas of law or which areas that the Moral Character Determinations Committee specifically focuses in on in making their moral character determinations translates into areas of actual attorney misconduct. And the first area that I'm going to discuss is the unauthorized practice of law. And in the unauthorized practice of law in the profession, we usually charge our respondents, that's what we refer to as the attorney who's subject to state bar discipline. He'll be charged with a violation of Business and Professions Code Section 6068A for failure to comply with laws. And as a component of that charge, we have a violation of Business and Professions Code Section 6125, which states that you must be an active licensee of the State Bar of California in order to practice law, and also Business and Professions Code Section 6126, which makes it a misdemeanor for anyone holding themselves out as entitled to practice law or actually practicing law when they are not an active licensee of the State Bar of California. As an example, suppose you have the situation where you have an attorney who's been put on actual suspension by the State Bar of California and has received a Supreme Court order. But in spite of that Supreme Court order, the attorney during the period he's on suspension makes a court appearance, or he gives legal advice to a client. that would be a clear-cut example of the engaging in the practice, the unauthorized practice of law. We usually break it down further depending on the extent of the misconduct as to whether moral turpitude is involved, and that's under Business and Professions Code Section 6106, which states that the attorney is subject to discipline for any acts involving moral turpitude, dishonesty, or corruption. And to have a finding of moral turpitude with the unauthorized practice of law, that's usually a case where the attorney knew or is grossly negligent in not knowing that he's not an active licensee. And that situation usually arrives most of the time when the attorney, has a breakdown in communication in regard to the attorney's notice that he's been suspended, or sometimes it's actually when the attorney is represented by counsel and he'll say there was inadequate communication between the attorney and his counsel into whether or not the attorney knows that he has been suspended from the practice of law. So that is a very common occurrence that we have with regard to attorneys who are disciplined for engaging in the unauthorized practice of law. And if you have any questions at any time in regard to any of these areas, just feel free to just jump in and ask, and that's perfectly fine.
I have a question about that topic.
Sure.
Does the bar only look at convictions for the unauthorized practice of law, or does the bar get involved in investigations to find out, for instance, an applicant has been advertising themselves as a paralegal, but yet indicates on their website that they're doing things that they shouldn't be doing?
Oh.
Paralegal, that they're actually doing things that lawyers do.
Oh, yeah, the attorneys that we discipline, it's usually reported by either a client or the court. A lot of times it's the court will check the bar numbers and they'll notify our office. We'll get we call that a reportable action from a judge. We'll say, hey, I checked this attorney's bar number. He just made an appearance in my courtroom and I see he's not active, he's on suspension, and we'll prosecute those. It's very rare that the case would come to us as a conviction of a licensee. It's usually self-reported by clients, opposing counsel, judges. It's somebody else. So, yeah, that's a very common occurrence.
I have a question that's related to this. What if somebody is practicing law, but they're not a licensee? You know, it's like unauthorized. They're not licensed. They didn't go to law school, whatever. Is that, I assume that's a felony, correct?
Well, we have a separate unit, we call it our non-attorney unauthorized practice of law. And unfortunately, as the Office of Chief Trial Counsel, we're not entitled to criminally prosecute those offenders. That really is the domain of the district attorney or the criminal prosecutors. But we can seek injunctive relief, which is what we do in our efforts to terminate any of those non-attorneys who are practicing law, and it usually occurs in the immigration context. That's the most likely scenario for that situation. Another area that...
Michael, just to want to weigh in just a little bit. You have a UPL unit, I think in OCTC, that will issue cease and desist letters.
That's the non-attorney unauthorized practice of law unit.
The non-attorney practice of law. So OCTC will in fact issue cease and desist letters when appropriate, and then make referrals to the DA's office also when appropriate.
And that can apply to your students. Sometimes the students, early graduates, get a little over anxious.
That is true. Before they are sworn in, we did have a recent case of a prospective attorney that hadn't been sworn in but jumped the gun and was charged with engaging in unauthorized practice of law.
For us, oftentimes it's the applicants who are practicing law. We find out about that, and I have to say, somewhat frequently deny them entrance to our program because of it. So it's become a big focus for us recently, and we've had the impression that it's been a larger focus for the bar lately. Is that true? In other words, more of a focus on the unauthorized practice of law as compared to before.
I don't know if it's a particular focus, but as the percentage of cases, since I've been with the State Bar, it has been a large part of our prosecutorial, the charges that we have brought, but it's always on the front burner for our office.
All right. I think for us, it's the fact that you can find out a lot about people by going on the internet to see what they're representing themselves to be and what they represent themselves to be doing. So for that reason, we've had more of an emphasis on it lately. And I guess that the bar has been in the same situation with the internet available to check on such topics.
Yes, we have. Okay, the next area of that I've been asked to make a presentation on concerns violations of court orders. In the Office of Chief Trial Counsel, when we prosecute an attorney for violating a court order, that's under Business and Professions Code Section 6103, which basically states that, I'm not quoting it, I'm just paraphrasing, all attorneys, you have a duty to obey any court orders that the attorney has knowledge of. And in prosecuting violations of court orders, a typical example might be where the court has instructed the attorney or the court has instructed an attorney to pay sanctions, perhaps in connection with a discovery motion or any other violation. But the key to that prosecution also is that the attorney has to have knowledge of the court order. And we've had issues where the attorneys haven't been present in court and they've been sanctioned, and the attorney will always state that, well, I never received notice of the order, or there was a problem with his mailbox, or the attorney had changed his address. So that it's important for our office when we do these prosecutions to make sure that the attorney does have knowledge of the order. However, knowledge of the order, that doesn't mean the attorney can simply not open his mail or fail to, evade the court orders. There are, in fact, we have one case which says the attorney cannot engage in what we call willful blindness in regard to the order that has been issued. So that's how we are able to circumvent any evasive tactics by the respondents in terms of their knowledge of violation of court orders.
With respect to the moral character determinations, sometimes we'll get an applicant, and I'm kind of jumping in to see how it applies to what we're doing, who maybe committed a minor offense, ran a red light or something of that nature, but then failed to pay their fine, failed to show up in court, and failed to essentially comply with court orders. So their actions after the criminal act are almost worse than the criminal act itself. And so as we kind of talk about how we deal with these things, that's one of the things that I think what we're looking for you to kind of give input to is say, how do you deal with someone who violates the court orders when the initial crime was perhaps minimal? Something to think about as we go on the road.
I mean, I'm just not familiar with that procedure. Do you wait for the court to find a contempt order? Or do you guys proceed independently of what the judge that issued the order does?
No, there may not be a contempt order. There may be a notice of ruling or a minute order issued in connection with, say, in a dissolution matter, the attorney was instructed to hold the funds from the proceeds of the sale in a special client trust account, and he doesn't do so. In addition to other charges that we might file, he failed to obey the court's order. And if it's referred to us, or the opposing counsel, or in the dissolution matter, they may bring the order to us or say the attorney, he violated it. So it doesn't have to come from the court. We get orders, particularly a lot of times, sanction orders where the attorneys fail to pay sanctions to opposing counsel. Opposing counsel will report the violation to us.
Procedurally, the court might make a determination and withdraw that order while you're in the process. Don't you contact the court at all?
As part of our investigation, we investigate every single one of these. We don't just receive the order and say, oh, you know, we're going to prosecute the attorney. They're fully investigated. We've usually subpoenaed the court file to make sure the order is a current order. We'll make sure there hasn't been any subsequent action taken, perhaps setting aside the order. We recently had a case where a nunc-pro-tunc order had been issued, which eliminated or corrected the original order. So we do our due diligence in terms of before we do our prosecutions on violations of court orders.
If you actually file the charges, does that affect the case that's proceeding where he violated the order or she violated the order so that gets put on hold? Or do you know? No,
we don't have jurisdiction of the Superior Court. The Superior Court, those court proceedings will proceed. Now, we have had situations where our state bar court proceedings might be abated pending further resolution or clarification of something that happens in the Superior Court, but their proceedings are totally independent of one another.
So we don't know of any court rule. The bar is saying this is bad enough, we're going to prosecute you and possibly take away your license, but the court's not necessarily notified, and the client maybe doesn't even know what his attorney's doing, and the court thing proceeds with an attorney we think shouldn't become an attorney. I mean, it seems there should be some court rule that connects those two, but you don't know of any.
Yeah. I'm not aware of anything, and we don't intervene in ongoing civil litigation. Okay, another area that I've been asked to discuss is professional discipline or neglect of professional obligations. That is, in terms of state bar prosecutions, we'll usually prosecute the attorneys for violations of former rule of professional conduct 3-110A, which states that a member shall not intentionally, recklessly, or repeatedly fail to perform legal services with competence. And effective November 1st of 2018, we now have a new rule of professional conduct, Rule 1.1, which encompasses what former Rule 3-110A stated, and also Rule 1.3, which deals with diligence. And those are your basic, what you think of when the attorney fails to engage in providing legal services that he is employed, retained to perform. For example, the attorney who gets a personal injury is retained to file a personal injury lawsuit, and he waits past the 2-year time limit and the statute of limitations is blown. We would charge that attorney with a violation of Rule 3-110A. Or if an attorney is employed to obtain a home loan modification and fails to perform or fails to obtain the loan modification, we would charge that attorney with a violation of Rule 3-110A. And we do get other cases where the attorneys fail to make court appearances, again, in a personal injury context, if the attorney was retained as plaintiff's counsel and he failed to serve the defendants, and ultimately the case was dismissed by the court. So the client loses their cause of action. That would be a violation of former Rule 3-110A and new Rule 1.1 or 1.3. And those types of cases, those are very common. we get cases that begin as minor type violations. It might begin as a discovery violation, but then subsequently the attorney doesn't provide the responses, doesn't inform the client, and a terminating sanction is ultimately issued so that the attorney's or the client's case is dismissed. That would be another example of a violation for what we call those failures to perform. There are other associated violations along with those, but just for our purposes here, I think it's the neglect or professional obligations. There is a fine line between some violations. Some may be construed as simple negligence versus intentional, reckless, or repeated conduct. And if it's like you failed to respond to the interrogatories, but a motion hasn't been filed, we might say at that point, I don't think we would prosecute that at that stage. That's more so of a minor violation, and it's usually until some severe action has been taken against the client that we would get involved in charge of a violation of the failure to perform. Next area is...
Michael, can I ask?
Sure.
So you talked about violating lawyer obligations. What about if he violates his notary license or he violates his real estate license? How does that apply in your case? And then for us, when an applicant comes in and says, you know, they've had their notary's license revoked or had their real estate license revoked, that affects our moral character determinations. So I'd like maybe you speak it on from your area.
We don't, like if it was a notary license or a real estate license, we wouldn't get involved in that. But for moral character purposes, that is something that could be considered discipline that does go to the moral character. The only time we would get involved, say perhaps if there was an issue on the original discipline for the attorney with regard to, let's say it's a real estate license. The real estate board, they have their own separate disciplinary entity, and if they would impose discipline, then that could come back to us as what we call reciprocal discipline as a J case is what we call it for jurisdiction. So we wouldn't be the originating party of that discipline. The real estate board or the whatever licensing agency is in charge of that particular area, they're the ones that would do that. We would impose what we call reciprocal discipline if the case came to us. That's a similar situation is when an attorney is licensed in 2 states to practice law, let's say Nevada, and the Nevada bar disciplines an attorney under their proceedings, but the attorney's also licensed in California. Because the attorney's been disciplined in Nevada under Business and Professions Code section 6049.1, we can do reciprocal discipline here in California based on that. So while we wouldn't be the originating entity imposing the discipline, after either the entity in the foreign jurisdiction or in this case the real estate board imposed their discipline, then they would refer to us as a multi-jurisdictional case, a reciprocal jurisdiction case, a J case, and then we would prosecute that matter. So that's how that works. Okay.
Could I ask a quick question?
Sure.
This number of cases you're talking about, it's not a whole lot during a year, is it? Maybe 100?
The reciprocal jurisdiction cases?
No, the general unprofessional conduct, 1.1 and 1.2.
Oh, I don't have a breakdown of the specific numbers, but I just generally can say that's one of the more common charges that we do bring.
Well, and so what I'm curious about, this is probably good burial to do, but do you do a study to figure out, is there something in common with most of these attorneys? Do the vast majority of them come from non-ABA law schools? Do the vast majority of them
something we could look at before they become lawyers, any kind of indicators yet. I mean, the vast majority of them had alcohol problems. You don't have any information on that. So where we're looking before they become lawyers.
I'm not aware of
Yeah.
anything
Can-
breaking it down.
Can I jump?
That far.
Can I jump in, Michael? So, and this goes to Jim's point as well. And, you know, in a few minutes, a little further into the agenda, we're going to talk about the same areas that Michael's talking about in the enforcement context. We're going to then talk about them in the application, the moral character context. But in this case, when we talk about discipline in other professions or violation of professional ethics, maybe the quintessential example would be Stephen Glass, who violated journalistic ethics. You know, we're looking at that in the moral character process to try to have some predictive value in you know, maybe the person who violates journalistic ethics, that might be an indicator of a possible future 3-110A violation if that person should become an attorney. So some of the areas that Michael's going to talk about in the enforcement context, the precise situation won't come up in the application process by definition because the person's not an attorney yet, but you know, that's the sort of thing we're going to look at, maybe get some guidance with respect to the applicant based on their behavior in other professions.
Well, because what concerns me is we're saying, okay, we're going to set the standards for who can become a lawyer and who can't. And that standard is because if we let these kind of people become lawyers, they are more likely to commit a violation. I can't find any information about that. Where you're saying, okay, we know he violated, we're going to assume he was a bad journalist, he's going to be a bad lawyer. I can see the correlation, but I can't see the correlation between some of these other things. Maybe it's the word moral is a little bit too big. I mean, 2 drunk drivings mean the person's going to be a bad lawyer. Is there any indication of that? A marijuana drug conviction 10 years ago. Is there any indication of people that did marijuana? I mean, if we don't know who's violating, what are we trying to prevent?
Well, and it's difficult. Again, you know, as we've mentioned, it's difficult to come up with a bright line in terms of, for example, a specific criminal conviction.
I just like a gray line.
Right, a gray line. I guess that's what we're after. It's really the individual circumstances that matter, and you know, this goes back to something I think Mark was talking about earlier. One of the difficulties in giving prospective students, law school students, you know, bright lines and are they going to get through the process, is the fact that rehabilitation is such an important factor that we look at. So somebody who comes to you before their 3 years of law school and says, I did this last week, am I going to make it through the moral character process? The answer might be, well, it depends on what you do during the next 3 years. And that's, I don't think that can be understated, the importance of the rehabilitative process, which goes to the heart of why there's no criminal conviction or any misconduct that per se excludes somebody from being admitted to practice law.
Well, no, I agree. We have one of my faculty members is on the international board of AAA, and we have a complete group that we've worked with many law students, but we had to know first in advance, and so we have to ask those questions. And then one who refused to help, you guys refused, and I was happy, until he went through rehabilitation, and it took him 2 years. He didn't want to listen to us, but he listened to you guys.
Okay, moving along. Another area that I've been asked to discuss concerns the abuse of the legal process. And in this regard, we would prosecute attorneys who have abused legal process under Business and Professions Code Section 6068C. And incidentally, Business and Professions Code Section 6068 specifies a laundry list of duties that attorneys are required to undertake in practicing the law. And one of those duties under Category C, it says you have a duty to counsel or maintain those actions, proceedings, or defenses only as appear to him or her legal or just, except the defense of a person charged with a public offense. Now, we call prosecutions under Business and Professions Code Section 6068C prosecutions for the attorney maintaining unjust actions. And some examples of some of the prosecutions we engage in for that type of conduct include attorneys who file frivolous appeals, attorneys who have been determined to be vexatious litigants, attorneys who have adverse civil judgments against them for malicious prosecution or abuse of process, or some type of conduct where the attorney, it's usually repeated conduct, in which the attorney has received some type of sanction by the court for filing frivolous motions or wasting court time unnecessarily. And those cases, while difficult to prove, they usually are very labor intensive, because a lot of times you have a lot of prior litigation that an attorney will have to go through before he's been determined to be a vexatious litigant. And while we try not to relitigate the underlying civil matters, we have to bring in evidence from those matters as to why the attorney should be disciplined for filing any unjust actions or bringing anything before the court that isn't legal or just. And normally, a lot of times in connection with those cases, we'll have sanction orders, and they're usually severe sanction orders, in the realm of $10,000 plus sanction orders, or adverse civil judgments that can be in the six-figure range. So another area I've been asked to discuss here today concerns attorneys who have engaged in fraud. And for the fraudulent, any attorneys who's engaged in a scheme to defraud, we would prosecute that under Code of Civil Procedure Section 6106, which is, again, I previously mentioned, that is defines moral turpitude, dishonesty, or corruption. Attorneys engaging in any act which constitutes dishonesty or corruption or moral turpitude. Some examples of prosecutions for schemes to defraud: for example, if an attorney was part of an insurance fraud ring involving staged accidents, or we've also prosecuted securities fraud cases, anything where there's any type of nefarious misconduct. Those cases also, when there is a scheme to defraud, they can be difficult as well, because you usually, you always have the victim, but proving the actual underlying misconduct, that can be difficult also. And the final area I've been asked to discuss, just in terms of misconduct, concerns candor and omissions. And for attorneys who have a lack of candor or omit facts, we can prosecute those violations under two different sections, one of which is Business and Professions Code Section 6068D, and that usually concerns a lack of candor towards tribunals. We call that seeking to mislead a judge. And under Business Professions Code Section 6068D, some examples of our prosecutions under that section will involve, perhaps if an attorney makes a misrepresentation to a judge during a mandatory settlement conference. There is one case in which a personal injury case where the attorney had failed to disclose the fact that his client was deceased. And for personal injury cases, that means the client would not be entitled to recover general damages, therefore it would decrease the value of the case to just the special damages that are involved. Another example would be if the attorney, in responding to a discovery motion, say failed to respond to interrogatories, there was a motion to compel, and the attorney made misrepresentations in his declaration saying, I had sent the interrogatories to the client, tried to blame the client when he had not done so, he or she had not done so. In terms of candor and omissions, another area we frequently will prosecute attorneys is Business and Professions Code Section 6068M, and that has two components, and that's the duties that the attorney has to communicate with the client. And the two prongs of that are the attorney has a duty to keep the client reasonably informed of significant developments, and the attorney also has a duty to provide the client with prompt responses to reasonable status inquiries. We have situations where the attorney has, I gave the earlier example under a violation of Rule 3-110A of the Rules of Professional Conduct, or former Rule 3-110A, if the attorney had blown the statute of limitations. A lot of times that happens, but the attorney will not inform the client that their cause of action has been lost. And then usually when the attorney ceases communication with the client will then contact the state bar and make a complaint against the attorney. So that's, it's a misrepresentation by omission, by if the client had spoken with the attorney and the attorney told the client everything about the case except for the fact that the client hadn't, or that the attorney had blown the statute of limitations and there was no case. And sometimes we have situations where the attorney will just mislead the client on and on. The client thinks there's a case pending, and then ultimately either the attorney will come clean or the client will call us and say nothing's happening on my case, and we'll subpoena the court file and find out, well, we have bad news for you. Your case was dismissed 2 years ago because the attorney failed to serve all the parties, or the case was dismissed because your attorney never filed the case because the rule of limitations had been blown. So in those cases, the attorney can make a misrepresentation or show a lack of candor by omission in failing to inform the client. So those are just some of the areas of prosecution, and a lot of times these different areas do overlap, but those are areas that the committee, or the moral character determinations group, they'll investigate in terms of coming up with their determination as to whether the applicant has good moral character. Okay?
Thank you, Michael. Any more questions for Michael Duchette? Okay, so let's move on.
I still have a question.
Go ahead.
Along the lines of what Patrick was saying, you know, I think part of what we might be trying to consider is what is the thread that leads to those issues? So is there any possibility, would it be feasible to identify, first of all, I know you've provided us with a number of denials, but in terms of total applications, how many of those people had disclosures? So, you know, what is the total number of disclosures versus the total number of denials? And then, you know, trying to figure out the thread out of these individuals who are prosecuted as attorneys, how many of them had moral character disclosures? Just trying to find kind of the thread that ties this all together.
Can you say a little bit more about the disclosures?
So, you know, if every attorney who's being prosecuted for misconduct happened to have disclosed and subsequently been admitted, that would be a pattern that I think would be informative. think it's unlikely, but it would be useful information.
So disclose what, though?
Well, I guess it depends on the categories that we develop throughout this conversation.
And this is the subject of the study that Debbie authored that we will talk about at a future meeting. But yeah, whether there's sort of any correlation between disclosures in the application process and future discipline.
And so even just knowing the total number of applicants who did disclose something, I think, versus just the number of denials, I think that would be helpful. Are 80% of applicants disclosing something, or 10% of applicants disclosing something?
And that's something we can talk to the Office of General Counsel about and see what the parameters are of what information we can provide.
I mean, speaking just generally and not having numbers in front of me, I know it is a good number of applicants disclose something to us. So anytime there's something that needs to be looked into further, then that's when it comes up to an investigator. So if it's something that has no disclosures or very minimal information, then it's cleared in pre-processing. So anything that comes up to an investigator, there's something that has prompted that needs further investigation. So it might be just difficult for us to determine specifically, again, since the system didn't track that, but I mean, what would you say, Mark, like 60% have something disclosed that would come up to the investigators?
You mean of the total number of applications that we get per year?
Approximately.
That's right. I think probably about 40% are cleared fairly quickly without any issues whatsoever, but the other 60% approximately come into the Office of Investigations for some investigation, much of which is, fairly sort of initial and not in-depth at all. It's just a very, very few number of cases that actually require more in-depth investigation. But there's a good number that, come, through the gate into the Office of Investigations, only because there might be a question or two that needs to be asked and some clarification with respect to some issue that was that arose in their backgrounds. But those are cleared pretty quickly. So I think that's about right.
Helpful for us to know, you say disclosure comes in 40% and you automatically almost approve half of those anyway. I'd like to know what the basis for that is. That you say it's not important enough to look at further. I mean, it would help us if we know what your guidelines were.
With respect to those that are sort of kicked forward for a little more scrutiny?
Or those that are not kicked forward. I mean, what is it you're choosing not to kick forward, and what is it you're choosing to kick forward? We don't know what that guideline is.
And I think we could probably provide.
Have we shared the level 1, 2, 3, 4?
Exactly.
Yeah.
I thought we presented this in the
Yeah.
last meeting.
I thought, that's right. And we do classify, and I think this was in the initial meeting where we classified the sort of types of conduct that arise in, low level,
It
2,
was
1,
tight,
2,
but
3, 4. That's part of all of that evaluation.
But it was a generic term, type of conduct. I don't know how you consider that. I mean, a deliberately not paid debt, $50, cash it aside. $1,000, we better look at that. That's what I'm saying. I don't know what the guidelines are for those general categories.
Right.
That would just be helpful.
I mean, we
if
could
we're gonna
probably
help
provide some
establish
more
rules.
clarification on that,
Yeah,
at a later meeting.
yeah.
Okay,
Appreciate it. Thank you.
you're very welcome.
Ready to move on?
I don't want to rush anybody, but yes. Okay. So we'll move on to 2C, discussion of the proposed mission statement and values to guide California's moral character statement and guidelines. I say this for the record, so that's why I'm saying that, okay?
Yeah, and so now we're getting into the content of the document that this group is going to come up with eventually. And we tried to draft a mission statement that at least begins to convey, the important values and the sorts of things we're going to be looking at during the process. And then, in addition to the mission statement, of course, we'll provide more detail. And I'll just go ahead and read what we have so far and then open it up for discussion. So, the Office of Admissions advances the mission of the State Bar of California to protect the public And I'll just jump in myself here and say that's the fundamental mission of the State Bar. And so that's important right up front. But to protect the public by ensuring uniformity, consistency, and transparency in the moral character determination process. Towards this end, these guidelines were developed to communicate clear and appropriate standards by which moral character determinations are made and ensure that appropriate consideration is given to rehabilitative efforts undertaken by applicants. Applicants have the burden of establishing the requisite moral character by demonstrating possession of traits critical to the ethical practice of law, such as candor and honesty and respect for the law and the rights of others. And then we listed several of the most important guiding values for the moral character determination: public protection, uniformity, consistency, transparency, clear and appropriate standards, and guidelines which are easy to understand. Those are sort of the ideas we tried to build into the mission statement. And I don't know if anyone has any thoughts now about that, or it's something that people can think about, we could always come back to as well. And some of, these ideas are already captured in a couple of, the moral character statement that's already on the State Bar's website. And the factors considered during the moral character process, which also already exist, but hopefully we'll be able to consolidate that stuff and provide some more clarity.
I wonder if it's possible, my understanding of the mission of the State Bar is that it's three-pronged. It also includes promoting justice and diversity, and I wonder if it's important to put that up front as well, given that that might guide how we do, how the process of moral, or the policies around moral character are implemented. I've made the point that given the racial disparities of the criminal justice system, that over-relying on criminal records can thwart diversity goals that the bar might have. So I think it's just important to keep those three. I would suggest that it might be important to keep those that threefold mission uplifted.
That seems like a good idea to me. And, I'll take notes here, and then we can redraft as needed. But yeah.
I had another question, which is when Michael went through sort of like what were the substantive categories that trigger attorney discipline, what we didn't talk about were the process that attorney discipline, what are the procedural requirements or safeguards for attorneys? And I didn't know if in sharing that information, Michael or David or Jim, we were supposed to be thinking about, well, these are the categories, and then that there should be some kind of parity. But if we are supposed to be thinking about it in that way, when I see that the applicant has the burden, I know, and correct me if I'm wrong, Michael, but it's flipped. The burden is flipped when we're talking about attorney discipline. So I wasn't sure, Jim, and maybe I missed it when you did the introduction, like what we're supposed to be taking from what Michael presented to us in terms of how we're thinking about our work. Should we be thinking that there should be parity? I know there are some who argue that there should be more parity, but maybe we're not, or maybe we are substantively but not procedurally. I think it would be helpful.
You're right.
And the burden thing triggered me.
You're correct that there's a different burden. The applicant has the burden of showing good moral character.
Yep.
And in State Bar Court, in enforcement matters, the State Bar has the burden of showing by clear and convincing evidence that there's been an ethical violation. Those burdens are not going to change. I think the idea of discussing the enforcement cases is to just sort of guide the working group's thinking in terms of the sorts of issues that come up when attorneys commit ethical violations, so that we can try to incorporate, the characteristics that those attorneys might have into the moral character determination process.
If I can jump in as well, I think during the last meeting, it had come up, I don't remember who brought up the question, but we were talking about a couple topics, and the question came, well, how does this impact an attorney's ability, or do we see this in licensed attorneys? So that's where we asked Mike if he could try to pull some of these topics out that we were going to be discussing and just give us examples of how they manifest themselves once you are a licensed attorney.
But the burden's pretty high, right? I mean, like, there's a lot, the number of, it is difficult to get disbarred.
As a broad statement?
Some people are good
Yeah,
at it.
Broad statement.
that's a
It's
very
difficult.
broad question. It depends on the extent of the misconduct, the respondents, whether he's got prior discipline.
Whereas
So-
it might be easier to get denied. Though these figures don't tell me that at all, given how small the denial rate is.
I suppose they do tell you that, right? That less than 1% of applicants are denied. Should we move on to the?
I have a comment about the mission statement. The only piece that concerns me is the reference to transparency, because at this point, I'm not comfortable that there is transparency. So I'd like to, potentially revisit this after we work through what we think this process should look like.
And let's be clear, the goal is to create transparency. We're currently there, you're absolutely right, there is not nearly as much transparency as one would want in this process. So if we sort of come to the conclusion of this process and you don't feel this word is appropriate in this mission statement, then we haven't done our job. So let's make sure that we're focusing on creating a system where there is transparency, and hopefully that everybody will be comfortable that those are accurate statements in there.
Okay, I don't want to rush anybody. These are very important topics, but I'm going to keep moving forward, but we can always go back to anything you want to go back to and talk about it some more, please. So moving on to 2D is discussion of moral character and areas of misconduct, compare and contrast California and other jurisdiction. This is where I think we really get into the meat of different reasons people get denied and how we might address those issues. So, Tara, do you want to start with this? This is the meat of it as I see.
Just waiting for Ezra to get it up on the screen, and then we'll go forward. I think I can control it from here, Ezra. Can we? Right, let's see. Nope, maybe not. Oh, I don't think we plugged in. Oh, yeah. I can go to the next one. Okay, sorry. So we'll be getting that part set up. So in these, looking at the moral character statement and guidelines that we're looking to create, our idea was to try to identify a lot of the topics that during the moral character process that we look at. So we've kind of broken them out by meeting, trying to kind of lump together the ones that are related, as well as save the ones that'll be, I think, larger discussions for the end, so that way we can try to go through and make sure that we touch on all the topics itself. So in this presentation itself, we'll talk about UPL, abuse of the legal process, violation of court order / respect for the law, professional obligations or discipline, fraud, and then candor and honesty. And as you see, we have it broken out. Of course, we can add more topics to these as you see fit. The last item on our agenda today is talking about future topics of discussion. So anything, again, that you'd like to add, we're more than happy to do that. We're just trying to create a jumping off point for the group to keep going forward. Let's see. And so part of it, sorry, then I'll pass it over to David again. So what we did is we looked at the current moral character statement and the factors that are available on our website. So these are the two things that both the law schools as well as applicants look at. And you'll see from both California and other jurisdictions, a lot of these topics that we end up investigating and looking into aren't thoroughly discussed. which is why we're now proposing language that we may incorporate into the statement afterwards. And of course, it's just a jumping off point. We can adjust it as we see fit, but that way to give more guidance to both the applicants and law schools themselves. So.
Yeah, and as I mentioned earlier, so these are parallel, these are the same topics that Michael discussed in the context of enforcement. The first one is the unauthorized practice of law. Currently, the moral character statement doesn't mention it. The second document, the factors, say an act of misconduct may include a sustained allegation of unauthorized practice of law. Not a ton of guidance there. What is this? And we looked at other jurisdictions and what they say. Most of them either really didn't mention it. You'll see that in Arizona and then again in Florida, they sort of vaguely, they talk about following the law and any orders of the court, et cetera, sort of vague references that might encompass the unauthorized practice of law. And what we did was I pulled some quotes out of some Supreme Court cases. Oh, there we go, thanks.
Dave, can I interrupt for a second?
Yeah.
I think it'd be easier for these people, for our committee to understand how this really comes before the Committee of Bar Examiners. And applicants in front of us, what have they done to get the unlawful practice of law an issue we're looking at? So, for example, we may have somebody who is an attorney in New York who comes to California working for a major corporation and forgets to register in California. Or you may get a student who jumps the gun and starts practicing law before they're licensed. Can you give us a couple of examples? This may be helpful. If you don't need this, it's fine, but it seems to me this would be helpful.
No, that's I agree completely. And this is actually an interesting one, UPL, the unauthorized practice of law, because it does differ from the enforcement area in the sense that, as Michael was discussing, I think more typically when somebody's already an attorney and they practice without a license, it's because he or she was suspended or disbarred, perhaps came from another state and practiced. More typically in the application process, what we see, not at all uncommonly, is somebody who comes to California to work for a large corporation and they fail for some period of time to register as in-house counsel. Which is a requirement, and they must go through the moral character process when they do that. Those cases can be somewhat difficult to assess. Jim might agree. If somebody comes to California and they're working at a large corporation, they fail to register as in-house counsel for 6 months because when they got to California, they talked to one of the partners who said that they weren't required to do anything, and then they find out that, oh, I was supposed to, and they immediately act. That's a different situation than somebody who does it for 3 years when they knew all along there's some evidence that they were aware of the requirement. I think that's one of the areas. And
I think a couple of the other examples that we'll see, sorry, David, once in a while, we will get an attorney who's prosecuted for aiding and abetting UPL, and then it so happens that the person that was practicing law becomes an applicant, and so then we would question them then for their activity and their part of it. I think the other one is, as Dean Clancy mentioned, there are a lot of people kind of jumping the gun, and we do look at the internet and social media and trying to see if they're holding themselves out as an attorney or capable to practice law. So we see it from both people licensed in other jurisdictions as well as those who are not licensed anywhere.
Yeah, and I think that the easy UPL cases are those where you have an applicant who's not licensed anywhere and suddenly they put up a shingle and, they're advising clients. It's happened before, we've seen it. But, those are easy cases to assess. The harder cases to assess are those that were described by Jim and Tara and David, where you have applicants who may just be referring to themselves on LinkedIn as attorneys or supervising counsel, but And that in and of itself might be a technical violation under 6125 and 6126 of the BNP code, which holds that you can't hold yourself out as an attorney unless you're licensed to act as an attorney. So those types of evaluations can be difficult because although they may be technical violations, they may not have implicated or resulted in any harm to anyone necessarily. But still, those individuals, that needs to be looked into to see whether there's anything more to what they're doing other than just holding themselves out. And in these UPL type evaluations, oftentimes the investigation has to center around whether or not are they really practicing law without a license, or are they in fact, operating as paralegals like within a law firm? Are they being supervised, by licensed counsel? So these are not necessarily, easy cases to evaluate, but in fact they're important cases to evaluate, because if the applicants are in fact practicing law without a license, that's indicative of a disrespect for the judicial system, disrespect for the law, and may in fact result in harm as a result of not really being qualified to practice. So these cases do come up, particularly in the registered in-house counsel context, but they are important cases that we look at.
So how this all fits into what we're doing, I'm going to give you my thoughts on this. Is currently, if an applicant is sitting before me and they've known for 2 years that they were supposed to be in-house counsel, but they just didn't get around to registering, I've got to make some evaluation to decide how does that affect their wanting to be found to be of good moral character. And that's the decision that I and the other committee members had to make a decision on. That now is being passed to staff. They're going to now be made to make that decision. And what I think it would be helpful for staff and for all the applicants, if we can say, generally, here's how we feel about that kind of applicant. And again, they're the whole range, from somebody who found out 2 weeks and immediately got their application in, as somebody who was 2 years and got their application in. Somebody who is working for a major corporation and never sees anyone other than their boss and people in their room, as to the person working for a small corporation who maybe is actually out there communicating with other attorneys. There's a wide variety of things. This is just one of many areas that we need to give answers to the new committee on, and we're going to be looking into. So that's kind of why we're looking here.
And the other question, I think, Jim, following up on that is, and how did we find out about it? Did they tell us in their application, or was it through some searching that we came up, that we discovered that information? Because maybe that impacts also what your how you read the situation.
Right, because sometimes we'll have opposing counsel who will say, so-and-so is saying he's an attorney, and he's sending me demand letters, or she's sending me demand letters, and they're not an attorney. Or somebody else who simply comes in and says, oh, sorry, I'm late, here's my application. So.
And it is an interesting area, too, because it's one of the few areas where somebody, potentially, if they're an attorney in another state and come and fail to register, they are, violating the statute, committing a misdemeanor, potentially triggering an enforcement action in the Office of Chief Trial Counsel, and it's relevant in the moral character determination process.
I also might add that UPL is not only a civil offense, it's also a criminal offense as well.
Yep, and so here, I just pulled a quote out of the Burbrower case, that makes the point that the reason that we care about UPL is, again, it's public protection, essentially. And this is some proposed language that could potentially go into the final document that this working group creates. Allegations of the unauthorized practice of law, that is UPL, will be considered during the investigation of an individual's moral character. UPL may include, but is not limited to, appearing in court or other tribunals, providing legal advice, preparing legal instruments or contracts, or holding oneself out as practicing or entitled to practice law, without the benefit of licensure or another status that confers the ability to practice law in a limited capacity in California, such as registered in-house counsel or in other jurisdictions. And, hopefully that gives applicants more to go on than they currently have, and conveys the importance of that issue. The next thing we looked at was abuse of the legal process. Oh, I keep forgetting. There we go. Currently, in the moral character statement, it mentions it really focusing on bankruptcy, and it says the fact that an applicant has availed himself or herself of rights under the federal bankruptcy laws does not reflect on moral character. However, if bankruptcy was resorted to in an effort to defraud creditors, moral character issues may arise. And that's just making the point that it's not a per se indication of misconduct to take advantage of bankruptcy. In other jurisdictions, some of them mention abuse of the legal process, most of them in a very cursory manner. Colorado has a little bit more detail there, mentioning vexatious litigants or frivolous lawsuits, or the raising of vexatious or frivolous defenses. Most of the other ones are fairly vague.
Okay, can I jump in?
Yep.
Jump in again here. How does this get before the committee? So we maybe have an applicant who, and you're asked, how many lawsuits have you been involved in? So this is part of, correct me if I'm wrong on this one, but so the application says, list all lawsuits you've been involved with. Most people forget they're divorced, even though they admit they're divorced. But they may say, I've gotten 3 civil lawsuits, 2 times I was a plaintiff, 1 time as a defendant. May say I've got 62 lawsuits I've been involved with. And so I think part of what this committee is going to say is, how do we measure that? Is that something we should even look at all? Or what should we do with that information? And I don't have answers here, but right now we do ask how many lawsuits have you been involved with. And generally we say we want a copy of the pleadings, or we want a copy of the judgment. If there's a judgment against you, have you complied with the judgment? So that information is being asked. Should it be asked? What should we do with it? I don't have answers yet. Larry?
Yeah, it's interesting you mentioned the bankruptcy, and I'm thinking of today's headline. It's could be subjective. For instance, today's headline of Purdue Pharma is going to declare bankruptcy, because of the opioid stuff. Now, there are some people that might say, well, they should be criminally prosecuted. And the declaration of bankruptcy is just a way for them to avoid criminal prosecution. And so it's a manipulation of the system. And that's a value statement. But it obviously comes into play. The other thing is with the lawsuits, some professions are much more subject to lawsuits than others, just because of the nature of the kind of business that these folks are in. So 30 lawsuits in one business might be no big deal, because everyone's suing everyone all the time. So it's just, it's very subjective.
No, that's exactly right. And that's another example of the difficulty in making a bright line. We couldn't say if you've been involved in 30 lawsuits, but people can be declared vexatious litigants, of course, before their attorneys, and I'm sure the judge would probably agree that it would be better that they not be a vexatious litigant with a law license.
If I may just address, I'm sorry, go ahead, Shelley.
To get to that point, though, there's actually a hearing and
right.
a due process, and so there's a level of protection for the individual. You don't just get labeled. It takes a lot. So if somebody gets labeled that, then they've earned it.
Yeah, with respect to what Larry alluded to, I just want to make it clear that, the fact that somebody has filed a bankruptcy is not considered, in isolation, an issue with respect to moral character. That's not necessarily going to ding an applicant because they filed a bankruptcy. They're entitled to do that. Some of the things that we will look at, though, in that context is if an adverse action has been filed within the context of a bankruptcy, then, I think that's something that we'd want to, and we do, in fact, look at, because, if it's an adverse action, we'd look at the allegations that have been made, and in fact, whether or not there's any rulings by the bankruptcy court that are adverse to the applicant that may in fact raise issues of candor or respect for the law, that sort of thing. And nor are the number of filings considered necessarily a bad thing. I mean, you're entitled to make use of the judicial system. But I think the moral character evaluation cuts deeper into, if there are issues that arise that affect, the abusive process, or, frivolous or vexatious actions or things like that. Those are the things that we're looking at, it, not necessarily simply because they filed a bankruptcy, although we do ask about that because it may lead to other things.
I also want to ask or follow up on the divorce, because we've gone out to do presentations at law schools, and it is something that we ask about in the application, and it seems to raise a lot of concerns. I think that there's a myth out there in the student population that a divorce could prevent you from becoming an attorney. And so I just wanted to find out how we use that information, because it's very similar to what you just talked about in terms of bankruptcy. It's not something that we hold against an applicant, but it is something that we ask to be reported.
That's right, because I think that the moral character process is intended to be broad, and it's intended to, what we're trying to do is look as carefully at the applicant's background as possible, in order to see to what extent there might be issues that that might be in the applicant's background that could raise concerns about their moral character. But simply because we asked a question doesn't mean that, if we ask about divorce, we ask about bankruptcy, that's not that's not a reason to deny somebody. And maybe that's something, part of this sort of transparency process, that needs to be identified, within the context of our guidelines, to say that clearly. Simply because you've been divorced doesn't mean you're going to, you're going to be denied, admission on the basis of moral character. But, that sort of information is important at least to have, so that we can see whether there's anything else surrounding that issue that might be of concern. It's not, Tara, correct me if I'm wrong, but, sometimes, we'll look to see whether or not there's any additional allegations made within the context of the divorce, or some orders or something that might raise issues. But I think it's a legitimate question to ask, but I do think that, in order to dispel some of these sort of misconceptions, by applicants, that it should be made clear that no, just because you're divorced is not going to result in your denial. It's just one sort of the initial step for a longer set of inquiries.
Yeah, can I just add, and it's really part of a broader question. What we're trying to do in the moral character process is look at characteristics that are particularly relevant to the practice of law as an ethical attorney, and a dissolution, involvement in a lawsuit might give one some hint about those characteristics with respect to specific applicants, and a dissolution is a lawsuit like any other in that sense. It's not the fact necessarily that it's a dissolution that's relevant. So the proposed language we had for this area, the abuse of the legal process, is up there now. Examples of abuse of the legal process include the filing of frivolous claims or the raising of frivolous defenses for the purpose of delaying proceedings, or bringing actions for the purpose of harassing litigants. Evidence that an applicant has abused the legal process may include the imposition of judicial sanctions or judicial designation as a vexatious litigant. Hopefully that gives people some guidance. The next category we looked at is violation of court orders. There's overlap, obviously, between some of these categories. But some of them we drill down and they're a little more specific. Currently, the moral character statement talks about respect for the law generally, as does the factors regarding moral character determination. There it is.
Can I jump in again on this one?
Yes.
Okay, so the applicant's in front of us, and this is probably the most common thing we'll see, is that they got a DUI or maybe even a broken taillight, and then they did a failure to appear, and then there was a second failure to appear. So it's the failure to appear, the failure to pay your fines, that, at least in my experience, is why it gets before the committee. So it's not the initial offense, it's the failure to comply with a court order, failure to pay your court-ordered restitution or something of that nature.
Kind of on the same.
Failure to appear, yeah.
The same topic Jen was mentioning earlier, for the civil cases, it's not necessarily that they were a participant in the civil case, plaintiff or defendant, but if there's a judgment against them and they, have not fulfilled that, or they're failing to pay for whatever reason, like those are reasons, things that we would take into consideration.
And then for the respect for the law, one of the things that I consider important is paying your taxes. And I understand a lot of people can't pay their taxes, and that's not where I have a problem with people, is the unwillingness to address the issue. So if they owe federal taxes or state taxes and simply saying, I'm sticking my head in the sand and not calling the IRS, I'm more inclined to have some issues with that person than if they're saying, look, I've worked out the IRS and I'm paying $10 a month. That to me, seeing they're addressing their problem, they're showing respect for their tax obligation, even if that's all they can do. So again, I'm not saying I'm right or wrong, but I'm kind of giving you some ideas where those things are when the applicant's in front of us. Sorry, Dave.
Oh, no. Appreciate it. And the other jurisdictions we looked at, most of them have a very general statement that, violation of an order of a court is taken into consideration in the moral character process. Fairly cursory. Respect for the law is mentioned often. This is a quote from the Kelly case when the court made the point that disobedience of a court order, whether as a legal representative or as a party, demonstrates a lapse of character and a disrespect for the legal system that directly relate to an attorney's fitness to practice law and serve as an officer of the court. And accordingly, the language that we drafted is below that. The practice of law requires diligence, respect for the law, and compliance with court orders. Violations of court orders, including failures to appear, failure to satisfy judgment, or failure to adhere to a restraining order, and other conduct evidencing a lack of respect for the law, are relevant to any moral character inquiry. And hopefully that captures, some of the sorts of things that Jim was referring to. Let's see. The next one, and this is the one we spoke about already a little bit when Michael was talking about enforcement actions, and that this is the, when we look at potential violations of other professional ethics, sometimes comes up in the real estate context, and I mentioned In Re Glass, the journalism context. And currently, we do specifically mention it in the moral character statement. We refer to fidelity and trustworthiness in other professions for which he or she is licensed. And then we also, again, specifically refer to it in the factors regarding moral character determination. And other jurisdictions that we look at, most of them do reference this area. It makes sense, after all. Ultimately, ethics is the topic that we're concerned with. And I don't know if you have anything to add, Jim, in terms of when you've seen this. I know that in some of the instances I'm aware of, it's come up, people who had real estate licenses where they have a fiduciary duty to a client.
We may also see sometimes, I think, people that are licensed, by the California Teaching Commission or other jurisdictions, or some sort of discipline or maybe a license revocation, as well as the medical profession. We get quite a few of those as well. So it's broader than I think just the real estate, but that is one that we see.
Yeah, and I think that we often see applicants who are licensed in other states. I think that's what you're referring to, Tara. I mean, as attorneys, and have had discipline imposed, and now they're applying for licensure in California. So we will, in fact, ask for the records from the underlying disciplinary proceeding in the other jurisdiction. So that comes up too.
Yep. And there's a quote there from In re Glass where the court just explicitly states that violation of ethical rules governing a profession of which the applicant was previously a member is relevant to a moral character determination. And so in light of that, the language we drafted for the working group, in making its determination whether an applicant presently possesses the good moral character necessary for admission to practice law, an applicant's adherence to or violation or neglect of professional obligations are relevant to a moral character determination.
This can come in sometimes when people get swept up in a bigger deal. We'll see where a boyfriend or girlfriend has gotten involved in some kind of transaction and brought our applicant in, and they aren't necessarily the main player, but they were brought in. And so I think the committee looks at that and says, you know, have you learned from your lessons? Are you likely to be brought into another problem? Again, this is hard to say what's happening in the future, but if somebody has been brought into a criminal endeavor, is that an indication that they would be brought in again, or is that an indication they're never likely to be brought again because they learned their lesson? And I think we get both sides of applicants. Some applicants we get in and we can feel fairly comfortable this is not going to happen to them again because they've learned their lesson, and others we listen to them and they don't get it. They still don't understand why they got in the problem in the first place. And again, I'm not sure how we share that with the committee, but that's at least one of the concerns I've had in the past.
Yeah, and again, that's, you know, where the rehabilitative process comes into play, and is so crucial to an individual determination. The next area we looked at was fraud, which I'm just going to skip ahead for 1 second here. You know, in the Hallinan case, the Supreme Court said, although the problem of defining moral turpitude is not without difficulty, it is settled that whatever else it may mean, it includes fraud. And so that's fairly clear. We currently mention it in the factors regarding moral character determination. It's not mentioned in the moral character statement, and we thought it should be included here. Most other jurisdictions just list fraud as a factor to be considered. And we tried to do a little more elaboration, and here's the language. Acts or allegations of deceit or fraud will be evaluated when determining if an applicant is of good moral character. Issues relating to fraud may include filing false legal claims, making false statements on an employment or school application, making false statements on a credit application, or a conviction of a crime for which intent to defraud is an element. So that gives some specific examples there that hopefully provide some guidance to applicants.
What if it's an omission by, you know, on an employment or a school application of information that was unintentional, I'm thinking in the context of municipal records, not including maybe all criminal convictions, but those of us who've seen that sheet know it's complicated, you don't remember how many times, you know, it could be, particularly if it's a conviction history connected to some history, right, where they were
Sure.
addicted and were going into court and didn't even know what was happening in the court. Would that fall into this category?
So we also have another category later, sorry to jump in,
Oh, no, no.
of candor and honesty. And so we're looking for material omissions. So we do get quite a few applicants who maybe they're not quite sure under what, section of the penal code that their case was dismissed or expunged. So I think we look at it in the totality. So if you have somebody who has a pattern of, not disclosing it, or sometimes they'll come out and say eventually that I didn't disclose this on my law school application because I was afraid of rejection. And okay, that's intentional. It wasn't an accident. So we do look at it, how it came about, the omission. So
But it wouldn't come in this context, it comes up later.
I think more so in the candor and omissions. I think this is more if, I can't think of an example off the top of my head that we've had recently for a law school, but this would be a much more serious instance, I think.
But in short, good faith, bad faith matters. To answer your initial question, if somebody didn't omitted, an item from a law school application or something like that, but did so in good faith, and that determination is made, that's an entirely different.
Do you want to include that kind of language?
Well, that's something the working group should think about, whether we should say something explicitly here or whether the sort of candor, honesty part, or frankly, possibly in the mission statement, something about intent. That's something to think about that we should.
Was it you, Larry, who mentioned the thing about divorce, lawsuits and divorce, people will not be putting it down, not that when you asked about lawsuits, they don't put down the divorce.
Somebody,
I
yeah.
did.
But that would be, again, like inadvertent, right?
The other one that we've seen on the committee has been people who had juvenile convictions, and then it gets expunged. So technically, do they have a record, or that kind of thing? And there's a lot of confusion over that. They're not sure if they're supposed to disclose that, and especially because the whole point of expunging juvenile convictions is to give somebody a clean slate.
Well, and sometimes lawyers ill-advise people, and I've talked to employers who have said, the applicant told me that their lawyer told me, and the employer says to them, I want a letter from your employer, and the employer will write a letter saying, well, in fact, it's false, but it is what the advice that they were given.
Yeah, and I think, Larry, in response to your issue, there's another section later on, in a few meetings from now, where criminal history is going to be discussed. And I think you're right, that clarification with respect to the impact of expungements, sealing orders, things of that nature, bit of a complicated area, especially with expungements, because we don't just have one expungement statute, we have multiple. And, so those are, definitely issues I think that could be and should be looked at.
So we've kind of looked at these things from three different angles. And I'm the lawyer who's sitting doing the moral character informal conferences, probably have the easiest job of everybody here. The State Bar people are collecting all this data and kind of seeing it on one end. You're seeing it from the student's point of view, and what little I hear from the students is they find this to be very complicated, very difficult process, and they want to avoid it, they don't even want to deal with it. So I think it's important that we find some mechanism that we all service the students better. I think that's kind of why I came to this committee in the first place, is I want to serve the students better. They're tomorrow's attorneys, they're the people who are our future, and how do we make it right for them? So that's kind of what I'm looking for your input. If you come back and say, we've interviewed our students and they tell us this application is just way outrageously wrong, then that's something that maybe we need to look at some more. Or how can we clarify the application? How can we avoid those mistakes from happening in the first place so we can serve the students?
To that end, Jim, is it possible to speak with the law content that's happening of what they're being asked? You can hear? Okay. Sorry.
But again, we're seeing it even a different way than the applicants see it. The applicants are not seeing it in written format, they're seeing it on the computer. Now, it may be easier for them than me, because I'm not a computer person, but I'd like to hear from the schools how their students see this application at some point in time.
Is it 7?
So it falls under the civil and administrative proceedings, and in that it gives the examples, and divorce is one of the ones that's listed, I believe. I don't have it in front of me, but. So these things that we're talking about, these topics, they're not all explicitly asked, yes or no, do you need to disclose them? But we were bringing up the topics that while we're considering the moral character application, like what we look for, so they relate to questions on the applications or things that we discovered during the investigation, but it may not be explicitly, have you been named like a vexatious litigant, something like that, so.
Is there some kind of reason or prohibition against just specifically asking the question? Have you ever been divorced? Are you married, single, divorced? Is there a reason that we don't do that? Just be very clear. Ask if you've ever been litigated and found to be a vexatious litigant. I mean, is there something that would prohibit that from happening? I can't think of, off the top of my head, I can't think of anything, but.
The short answer is I don't know off the top of my head either, but the longer answer is the divorce question, again, it would fall under, civil, have you been involved in any civil?
Right, but you're saying there's confusion, so why don't we take away the confusion? Have you ever been married? Yes. Have you ever been, or are you married, divorced? What's your marital status? And include a box to check for divorce, so that there's absolutely no.
Yeah.
No.
There are laws against asking that as an employer when you hire somebody.
Well, that's what I'm asking.
I don't think we should, I think we should simply say,
prohibited?
have you had a civil action, which would include a divorce? Just put it in the question.
Which I
Then
think,
you're not asking, or you're not, but yes, explaining that it's a civil action.
Part of the problem is most of the students don't read the application when they're completing it. That's what they tell us. We'll say, well, why didn't you answer it this way? And they'll say, I rushed through it. I didn't really read the instructions before I answered the
Well, we
questionnaire.
can't come up with any answer to that stupidity, I'm sorry.
I don't know what to do with them, but I want to share with you what I hear.
Tara, do you want to tell them the exact question?
But, okay, so I think Debbie's got it right there. So question 34 on it, it does. So we give examples for it, but Judge
Right.
Story was right, that we don't explicitly ask
Right, I
each
mean,
question individually, so.
What is your status right at the top? Here's my name, here's my age, here's my, whatever status. Married, single, divorced.
I think that would add additional concern about the level of scrutiny that's being applied to a person's marital status. If students, as Mark said, if students are already concerned about, or I'm sorry, as Amy said, if students are already concerned about why that question is being asked, I think that would exacerbate the problem.
And it may be explicit enough as it is. Have you ever been a party to, or are you presently a party to any civil action or administrative
Because that makes it sound like.
This includes, but is not
Yeah,
limited to.
it makes it sound like it's about the divorce rather than about being a party to a legal proceeding.
Well, and then another
Right.
way of clarifying it is also, and I think we've talked about it in some of in the context of some of these topic areas, is how just explaining how we use that information. Maybe there is no use for it, or it sheds light in terms of potential litigation that people get involved in. But I think being more explicit that way might be a way of just avoiding that concern that is raised.
I'm looking at the form, one of the forms that's attached to the application. It says record of civil actions, administrative proceedings. You're supposed to list the cases that you've been involved in. It says nature of cases, for example, small claims, divorce, personal injury.
It says
I don't see anything wrong with that. Mentioning it as an example of what you need to provide information about when it comes to civil actions. It seems to me that that's not going too far, especially since if you don't mention divorce as one of the possible actions, people might leave that out.
Okay, so the final area we looked at, and perhaps the most broad, but at the same time, perhaps one of the more important ones is candor and honesty. And currently, the moral character statement mentions it specifically, mentions candor. The committee considers evidence of candor. and then reiterates lack of candor in and of itself as it relates to moral character may be enough to deny certification on moral character grounds. And then finally, in making its determination, the committee considers evidence of honesty. And it's repeated in the factors regarding moral character determination. This is obviously an important area that needs to be mentioned.
Okay, I'm going to jump in on this one too and give you some examples. So we have an applicant in front of her in front of me, and they've got a DUI. And so we're looking at the DUI, and their blood alcohol is 2.4, 2.6. And so we asked them about it, and I said, what did you drink that night? I only had one beer. Well, there's something wrong there with that candor, because it's not likely that they got to be at 2.4, 2.6 with one beer. So it's not the DUI that's the problem. It's the problem that the candor about how they got to that point. Now, whether this is right or wrong, I'm kind of sharing with you things that are experiences to us. So when the person comes in and says, well, I had one beer and they had a 1.6, again, we have some candor questions. Can you think of other candor things that have come up?
I think sometimes we'll see also, so for example, if there's someone disclosed an incident, maybe an honor code violation or a criminal matter on their law school application, but then when they disclose it to us, the factors that they've given us are significantly different. We'll ask, why is there a discrepancy? And sometimes they, it's due to time, something like that, it's a lapse, or it seems like they're trying to downplay what actually happened, the seriousness of it, and their current disclosure doesn't really match like the facts of what happened based on what they previously said, based on like the police report, things of that nature. So we see it in a lot of different facets.
Yeah, I don't think, I mean, we could sit here and talk all day about how applicants, get into trouble by not being candid, and, I think candor and honesty are two different things. I think of candor as the requirement that one be complete, and honesty being the requirement that someone not be deceitful. But we see, we could come up with a laundry list on how that happens and when it happens, because it really is a sort of a significant issue, in this context. People leaving out criminal convictions, people not disclosing all their civil actions when in fact they're very, very apparent. There's no reason why they should have omitted that information. And frankly, the Supreme Court has instructed us very, very clearly in multiple cases, the last one being in In re Grant, that honesty and candor are probably two of the most important factors that we must consider when assessing moral character. Larry?
Yeah, it's interesting. Honesty, I think it is kind of easier to judge, because it's more quantitative. You told the truth, you didn't tell the truth. Candor is, it's up there with remorse and rehabilitation in a lot of ways. It's very subjective and nuanced. I've sat in on a whole bunch of these things, the moral character interviews. A lot of it is how they present themselves, Those of you who are trial lawyers, you know the old story about, who's a good witness and who's a crummy witness. And I'm also reminded of the old joke, attributed to Louis Mayer, which is, it's all about honesty. If you can fake that, you got it made. I have seen in some of the moral character informal conferences we've done, people who it's really obvious to me that their ability to perform had a lot to do with how they came across to the panelists, and that had they been better or worse at it, the outcome might have been very different. And candor is one of those things. I think that it's a very subjective kind of thing. It's going to be really tough to nail down.
And it also, I think, to build on that, during the informal conferences, a lack of candor, I think it's safe to say, is often sort of a general characteristic rather than, there might be a specific instance we know about the blood alcohol content or something like that, but when you sit in a room with someone and talk to them about multiple subjects, sometimes it's fairly clear that they're not being candid across the board.
And I guess part of the problem is that as lawyers, we're kind of trained to come up with excuses, to come up with justifications, to answer why something didn't happen the way it did. And the informal conference is one of those times when you have to stand in front of the judge and say, I screwed up. And that's kind of the hardest thing for an attorney to do. But what I learned early on, you're much better off doing it because the judge respects that generally. If you say, I screwed up, I need help with this one. And when the applicant comes in and says, yes, I really screwed up, lays it all on the line, it's easier for us to kind of to accept they understood it than the one who is loyal, his or her lawyer training wants to justify what they've done. I don't know why it happened. I don't really understand why that happened. And you know they know why it happened. They just don't want to say it.
Or maybe they can't even admit it to themselves.
Oftentimes, yes.
I want to say that what I've seen here is there's a lack of preparation at our law schools. We spend a lot of time explaining the bar exam, explaining what to do, explaining how to apply, but we do nothing in helping these people fill out their morals application form. I think there needs to be emphasis on that. It would save the bar a ton of time, and it would save these students a ton of time if they understood exactly what's going on. I've had 2 students come to me in the past 2 months claiming it's a political process. I've been denied because, and I said, well, can I see your morals application? Well, no, I don't want to show that to you. I mean, so it's a question. I think we need to look at doing this better.
You know,
preparing these students to fill out these forms. They don't understand it, and maybe the deans don't understand it.
I was just going to say that we're happy to, and we do, regularly give talks, give presentations at law schools to people, 3Ls going into their 3rd year who might be starting the process. And we don't walk them through the entire application, but sort of present what they're going to have to do. And believe me, I take that opportunity to tell them you're better off being honest and being candid and disclosing, hey, you have a number.
And maybe also we could make ourselves available during CS bars or the law school council, that way to open it up to questions from the deans or other administrators for things that you commonly see.
But as I see this process, we need your help to figure out how to be more transparent on our end so that we become more transparent to you. You can then work with the students. But I think we have responsibilities, yeah?
I mean, it's obvious, just tell the truth. I mean, I get it, we're trying to dance around it, but some people are just not gonna be truthful. So, I think the best we can do is give everybody the information, and they will choose to either present the evidence truthfully, or they're gonna slip and slide and do whatever they can to try to manipulate the system. Some people are built that way, and it doesn't matter how transparent we are, it's not going to change, which is sad but true.
There's no question. Some people are going to be like that across the board no matter what we tell them. I think there might be a middle group of people, though, who may approach the moral character process like litigation or something, going to your attorney analogy, and they think they're parsing the language of each question. They're trying to think of an argument in case it comes up later of why they didn't disclose it. And really those people, I think, are the people who at these presentations, when I just say, please disclose, 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 maybe that'll nudge them, in the right direction. And I'll just read, this was our the language we were proposing for this area of candor and honesty. An applicant's candor and honesty are primary considerations in determining whether an applicant is of good moral character. Issues relating to an applicant's candor and honesty may arise, for example, from a material omission or misrepresentation in an applicant's law school application or moral character application, or during the moral character investigation of an applicant's background. And hopefully that conveys the importance of, frankly, having candor throughout the entire process.
When you were giving examples, I was hearing often not just
that really goes to rehabilitation, which we have to spend
Yeah.
a lot of time on.
Okay.
So the,
fine, I just
the
wanted to
person who
clarify
comes in
that.
and says, boy, I screwed up. And we'll get an applicant who say, I was denied 3 years ago, and it was the best thing that happened to me because I reevaluated my life. I now see what I did wrong. I got my life in order, and now these are all the things I'm doing that I should have done 3 years ago. So, and rehabilitation is a tough area. We're going to spend a lot of time on it. So.
And I also just want to put out into the universe that, you know, I think you, Tara might have mentioned that, like, one of the sources of information that you look to, like, in doing police investigation is this, like, police report and probably other kinds of information like that. Like, just being aware that, yes, 99% of the time those are accurate and honest themselves, but we've recently seen that, you know, police reports can also be misleading and, and and if, so applicant could honestly, in his or her own head, be saying, this is what happened, and a police report could say something different, and it's not necessarily that the applicant is lying.
Absolutely.
I know that it doesn't happen all the time, like most of the time, but I think it, you know, particularly, you know, in the last 10 years in the literature around exonerations and things like that, we know that there have been misdeeds among the actors in the criminal justice system.
And that's,
I just think it needs to be said.
and that's a good thing to point out, because that's something we can address too. So if we have a police report and the police officer says A happened, we have an applicant that says B happens, what do you do with that? Who do you rely upon? Do you rely on the police officer more, or the applicant? That's a tough answer, and I'm not sure with that. And there are clearly applicants who, at least in my view, were wrongfully stopped because of something about them. And I just think, you know, I wouldn't have been stopped for the same thing this applicant was, and so that's not really fair that they're even in this position. So I at least think about that. But again, what do we do when we just have 2 points of view, the police officer and the applicant? Do we just say it's a tie and therefore we go with the applicant? I don't have an answer, but I'd like to talk about that.
Well, so the law has recently changed. Penal Code Section 851.91 allows for an arrest record that is not prosecuted within the statutory time period. So most misdemeanors are a year, or 3 years if it's a felony, for that record to be permanently sealed. So if that's what the criminal law is saying, then I don't think the State Bar should be taking that into consideration at all. We should follow the guidelines of 851.91.
Okay. But
It's not a tie, it's a non-factor.
But what if you've got example of someone who was, let's take the young person who gets happens way too often. They just taken the bar exam and they go out and party that night and get a DUI. Stupid, but we get more of those than we need. So they come in and say, I had 2 drinks, my blood alcohol was lower. The officer says, no, it was higher.
But that's a different situation, because now you're talking about something that's arguably that's been filed.
Yeah.
But there's a criminal charge pending. That's different from the police report where somebody wrongfully stopped for whatever reason, or stopped, or no action is ever taken. There's no complaint ever filed. Then 851.91 seals that record permanently. You cannot consider it for anything.
And that's probably a good point for us to make sure we
Right.
don't consider it.
So I deal with these on a regular basis. 851.8 is a factual basis finding, which is different and even a more heightened level of presuming one innocent. But I think our legislature, at least in California, recently recognized the difficulty that there is for individuals to meet that burden of proof, because then you have to hold a hearing of officers. Well, this is what I saw, and the individual saying, no, this is what I did. So to get past all of that tie, you're saying, the law was changed in January to allow for these individuals to have their cases permanently sealed. So those records are done. So I don't think we should be considering that at all.
Tara, could you clarify, because I believe that the application excludes you from disclosing arrests that don't result in conviction?
That's correct. And the only times typically that we'll ask about it is we may find out about it from a law school application or one of the references, and they just said, you know, DUI or criminal matter. We don't really know what happened. So then we'll ask the applicant, you know, were you required to disclose it? If so, why didn't you? Please provide us a narrative and any documents. Because otherwise we just don't know what happened in that situation, but they're not required to disclose arrests.
Right, so I'm curious as to why that would be coming up for Jim at all.
Well, no, I'm thinking of it more in a different context, where there actually was a conviction,
Okay.
where, I don't want to get particulars because I've got to keep confidentiality, where the police report says something happened. This person assaulted someone else, and they're saying there's no, I was the victim of the assault. It's just that I didn't report it first. That's why I was reported as the assaulter rather than the assaultee. But it actually wasn't.
Right, if there's a conviction, then
But the
there's a
conviction may be a DUI, so the conviction really wasn't on the assault. There's something in the report that is not
Yeah,
the matter of the conviction.
any sort of factual dispute. You know, there could often be factual disputes between an applicant and, you know, or potentially between an applicant and something that's said in the police report that ultimately perhaps wasn't relevant to the final conviction. You know, did you have 5 beers or did you have 15 or did you
But that's different, because that goes to the conviction, but if you're looking at the contents of the police report and going beyond what the charge is, I don't think that's what the purview of the moral character investigation should go into. Now you're going into uncharged crimes that may or may not, I mean, if they were convicted of it, that's one thing, but if they're not convicted of it, then they didn't have a trial on it, and now you're sitting as a trier of fact trying to determine what happened without a judge or a jury. You know what I'm saying?
Really, and that's why I'm
So I think
saying,
it's
maybe
like
we
you
need some
can't-
clarity that says we're
can't
not
go there.
to look at that. If it's not part of what he was charged or she was charged and convicted of, then we're not to consider those things in the report.
Right.
If there's a difference of view, we're just not to consider it.
The
I
only
think
thing you
that may
could
be a
just,
good answer.
would be, he says he had 2 beers, and the testimony came out that he had, you know, enough that it would be, the expert testified that it was 15. Then that would be the only thing you could look at. All the rest of it would not be relevant.
You know, another situation is, to think about is, although maybe the incident has been expunged or sealed, but what happens when, you know, could we, when we do at times consider the factual circumstances surrounding, for example, that may have nothing to do with the incident itself or the allegation of misconduct, but, you know, what do you do in the instance when, you know, the applicant has been arrested for DUI? Okay, there's been no conviction, we're not going to consider the conviction, but what we do know is that the applicant, in the course of that incident, kicked out the police officers, you know, the windows of the police officer's car, nothing to do with the DUI necessarily, and took a swing at the officer, and resisted arrest, but, you know, there were no charges filed. You know, should we not be able to consider, you know, those sort of extenuating incidental facts? You know, do they go to a legitimate, do they implicate legitimately the individual's moral character? I would argue that those sort of, you know, incidental facts surrounding the incident are important to consider. But again, this is something for you to think about.
Yeah, I remember a very early informal conference. I don't know if, Mark, if you remember it, he was
Let's be careful.
Right, okay.
Okay.
Anyway, we thought that there might be some racial bias on the part of the authorities. There was an incident in the guy's record. We thought that it really looked like a racial bias, and I think we ended up clearing the guy. So, you know, not denying. So, you know, and again, and it was a good example of, you know, just because the police say X doesn't mean it was about X.
But you make a good point.
But I guess my whole issue is not about, it's about due process. So if somebody's not charged with something that you're gleaning facts out of a report that is hearsay and inadmissible, I just have a real problem with the due process. So then you're asking the individual to come back and try to explain a conduct that they were never criminally charged with. So I think that I get what you're saying, trust me. My background, I was a prosecutor for 17 years. I completely get what you're saying, but just listening to what you're saying and how you're saying it gives me pause for concern, that there's a lack of due process. And I get that we want people to be candid and tell the truth. I think the application has to be blunt. We're putting lots of legalese in here, which is gonna get the legal brain going. The application should say, tell the truth and be candid and tell us what you've done. And if they mention these things, you can talk about it. If they don't, I don't know that you can go into a police report if you find out in another way and try to use that in some way against them. I don't know. I haven't done enough
Well,
things for me to be.
You know, my response to that, Your Honor, I'm sorry, I've been, you know, I've been in a courtroom too long. I can't dig that out of me yet. But, you know, what I think about is that we've been given a broad scope, purview by the Supreme Court to look into, you know, types of conduct that implicate a person's present ability to practice. You know, and if you look at the definition of moral character, good moral character, you know, as endorsed by the Supreme Court, and which is contained within our rules, you know, it gives you know, it requires that we look, you know, it's defined very, very broadly, and it's defined very broadly for a reason. You know, so that we, you know, it can be kind of a living document. We can, you know, move with, you know, as society moves, but also to be able to look at a number of different things that, you know, may very well implicate moral character within this context. So, so I think that's sort of what I rely on. So it goes, you know, beyond just convictions. It goes beyond, you know, we're talking about character, which is kind of a squishy area, I grant you. But you know, if you look at that definition, it's very broadly worded, and the Supreme Court has, you know, has instructed us to look at, you know, a wide area of conduct. Again, you know, for purposes of public protection and for the purpose of evaluating present fitness. I don't like using the word present fitness. It's not, you know, but that's sort of the language of the Supreme Court. So anyway.
So I think this is really good. I hate to say this is lunchtime because I really enjoying this part of the conversation. But my suggestion is that we maybe break for a quick lunch, do our lunch thing, and then come back and decide whether we want to talk about this more or move on. But I think this is real important. So let's break for lunch unless somebody wants to say something before we go to lunch.
So we have 30 minutes for lunch, and I believe it's next door, if it's there yet. Ezra just walked out, so I'm not sure.
Hello, Greg. Doing well. How about you?
Okay, so I might say back on the record. We're on item 2D still, the discussion of moral character and areas of misconduct. Again, we've only covered about 6 of about 20 of them. And so, Tara, why don't you kind of talk about, again, what we're trying to accomplish here?
So we just wanted to remind everyone, so the proposed language that we have, the intention is to give the students in the law schools more clear guidance as to what factors we are looking at. And that'll be part of the statement and guidelines. So rather than just bullet pointed lists of, we look at X, Y, and Z, actually give a little bit of an explanation or just examples of what we're looking for. And so we wanted to open it back up to see if there's any further discussion on any of these statements at this time. Or maybe the working group members want to take this home and, let us know your thoughts as you come across this, or we can keep going through it as we go through the other topics. But we just wanted to make sure we gave you the opportunity again to revisit any of the statements.
I would like to reserve time to review it and come back to it.
And maybe add some things to it, saying, I want clarification here, or this would be good to add to this point, or what about this? So those are all good things. And again, as we go through the next meeting's list, which is a whole other set of areas, we can kind of visit this too. The other thing, I'm going to step out of line here for a second, but if there's something else you want to add to the agenda, something that you don't think we're covering, would you let Tara or someone know, and we'll try to bring that up. Again, we're trying to find a solution here, and finding out what the problem is helps.
I would just briefly, if you're able to bring up any topics as soon as possible beforehand with the meeting, just because it takes us a little while to create the agenda and go through the approval process, and then we have to make sure it's posted 10 days beforehand as well. So.
Okay, so they're going to move on to then 2E, presentation of the updated informal conference procedures by Mark.
Oh. Okay, my turn. All right, well, good afternoon, everyone. What I've been asked to do is to introduce to all of you the new proposed procedures for how informal conferences will be conducted. Back in, well, first of all, for those of you who are unfamiliar with informal conferences, I think there are a few of you here. What an informal conference is it's an opportunity for applicants who have been identified with sort of more serious conduct in their background. It provides them an opportunity to be interviewed in an informal proceeding by a panel, and it gives the panel an opportunity to make a more personal assessment of the candidate, make a personal assessment of their insight, maybe fill in details and factual details, and to allow the applicant an opportunity to explain himself or herself, again, in a more personalized, face-to-face forum. So the informal conferences are very important, especially when it comes to situations that where the conduct is more egregious. Typically we have, correct me if I'm wrong, Tara, I think in the vicinity of we do maybe 250 a year, something like that, more or less. And the process for conducting those informal conferences will be changed, assuming that the Supreme Court adopts the amended admission rules that the Supreme Court is now reviewing. In the past, and let me explain to you right now sort of how informal conferences work now, and then I'll explain to you how informal conferences will work once the Supreme Court, I assume, approves the amended admissions rules. But presently, the way informal conferences work is that the program manager evaluates, as applications percolate up through the chain, depending upon what's in the applicant's background, it's the program manager that makes the decision as to which cases justify or require an informal conference. She notifies the...
I don't mean to interrupt, but could you explain to us who are program managers and how they're selected, what their qualifications?
Our program manager at Moral Character is Tara Clark. Prior to that, it was me. And yeah, so the program manager is the head of the department, ahead of that particular unit. Yeah, makes the decision as to whether or not a particular applicant requires an informal conference. A panel is then, she notifies the subcommittee on moral character, the chair, who in this case happens to be Jim Efting, and also creates, forms a panel of moral character subcommittee members, typically 2, 3, 4 members, who will then serve as the panel to do the interview of the applicant. These are members of the Committee of Bar Examiners and members of the Subcommittee on Moral Character. The interview is then conducted, and following the interview, the panel then decides, makes a recommendation, a recommended disposition, whether to deny the applicant admission or to grant a positive or some other interim measure, for example, sending them to the Lawyers Assistance Program, something of that nature. And then that recommendation is then presented to the Committee of Bar Examiners and the Committee of Bar at its next regularly scheduled meeting, and the Committee of Bar Examiner then accepts the recommendation or not. They can do what they want. Under the new amended rules, as adopted by the Board of Trustees in May of this year and is now pending in the Supreme Court, one of the fundamental changes that's going to occur is that it will be staff that will be conducting the informal conferences and making the decisions as to whether or not, making the moral character determination. Staff will be doing that. And the reason for that is because there were some concerns about consistency, for the applicants and the evaluation of those informal conferences and the conduct of those informal conferences. And it was felt that, the informal conferences and the applicants would benefit from a regular set of individuals participating in those conferences rather than a different set of individuals at every informal conference made up of a different panel of subcommittee members. I'll explain that, yes, for the most part, but as I go through the guidelines, I'll show you sort of how we're going to implement through the guidelines the amended rules that impact this particular area. So if I may, this is on average a year.
From the data we got this morning, that about 50 of the 250 are denied.
Yeah, well, whatever those numbers are. Yeah, something, yes, and that sounds about right. That sounds about right, Debbie. So what I'd like to do is just sort of walk you through what we've drafted as the proposed guidelines for implementing the new admission rules, shifting the responsibility for conducting informal conferences from the Committee of Bar Examiners to staff. And what you have, it's divided into two parts. And also what I forgot to add one more thing. The Committee of Bar Examiners under the new rules still has a role to play. And that role will be to serve as an interim administrative hearing board effectively for individuals who want to petition any adverse determination made by staff. If they want to petition that adverse determination, they will petition the Committee of Bar Examiners. They will present it. I'm sorry? They present themselves to the Committee of Bar Examiners. And well, that's under the proposed rules, and the proposed guidelines. So I'll go over that with you as well. I just want to go highlight some of the guidelines and give you a sense of how these informal conferences will be conducted in the future once the amended rules are approved.
Okay, Mark, I'm going to jump in for a second.
Sure.
And kind of go back a step. So you've got your student who's filled their application online, and it goes to the committee or to the staff, and they'll look and say, were there things we need, and maybe they'll write a letter saying, we need an explanation of where you were in the summer of 2018. And then the student will apply that, or we need a copy of this report, and they'll provide that. So they ask the student for a bunch of information. Once the staff believes they've gotten all the information they're going to get or need, then I believe what happens is the staff makes a determination that this person should pass or this person needs to move on to an informal conference. So that's where we get to the informal conference stage, is the student has been given an opportunity to provide all the information, has been asked information, and has provided the information or not provided the information.
If they pass at that point, it's over.
Then they're over. They've passed, and interestingly enough, because I just learned this, what happens is about every week or 10 days, the Committee of Bar Examiners files a motion with the Supreme Court saying these people have met all the qualifications, and the Supreme Court actually issues an order saying these people are now licensed to practice law, which is kind of interesting. I didn't know how that worked until.
Right, and also with respect to sort of the concept of due process, yeah, under the current system and under the system that that will be implemented once the admission rules are pending, are approved, applicants who are denied on moral character grounds still will have the option to petition the State Bar Court for further hearing, and both through the State Bar Court and then ultimately to the Supreme Court if they, if they object to the adverse determination. So if we could just start with the procedures as they will be applied now under, within, conducted by staff, and then after that there are separate guidelines for how the Committee of Bar Examiners will conduct the administrative the hearings. So when an applicant petitions for review of an adverse determination. So here we have the proposed guidelines for staff. Items section A and B are provides the notice requirement. How the decision is made. It reinforces the fact that the program manager makes the determination to invite an applicant to an informal conference. That's the same as it is today. And then section B provides the timing of the notice and when those notices should be sent out and when those notices should be responded to. And item C, section C, is another one of those provisions that remains current, and it's the same. This has not changed, that an applicant is not required to accept an invitation to confer, and nor will any negative inference be drawn from the applicant's decision to not attend. So that's the same principle as applies today.
Okay, Mark, I'm going to jump in for a second.
Sure.
Because I have things. So sometimes applicants will get counsel, and so they maybe will sometime in the process say, so-and-so is now representing me. And so now staff will deal with counsel to get information. So the applicant does have a right to have counsel anywhere along the process. And sometimes they'll say, okay, I'm going to do an informal conference and I want to hire counsel in that stage. And then we may even tell counsel, this is when we're going to schedule the informal conference. So I want to let you know they do have a chance to get counsel, to be there. Mark, you can talk about counsel later,
Sure.
but I want to talk about how counsel may become involved.
Right.
It says there's no action taken if they choose not to go, but doesn't it mean staff is going to send it to the CBE?
I'm sorry, they're not, this is a voluntary process.
Right, so if they don't come, staff's made a determination they needed to come, do they then just automatically refer it to
So it'll be, I think,
for violation?
so right now, the way the process works is that if an applicant is unable to come to an informal conference for whatever reason, sometimes, monetary, sometimes with their job, it's put on one of the agenda items, we call it the 501, for the committee to decide, and they review it as is. So it would be the same process essentially with staff. So rather than just referring it to the committee, we would make the determination
On the record.
on the record as without the applicant present, so.
Well, let's go back a step. So currently, if an applicant cannot be there, we still hold an informal conference when they're not there. And the 3 committee members or 2 committee members will actually go over the file and discuss the matter and make a determination or recommendation to the Committee of Bar Examiners based on the record. So even if
So it's not automatic.
it's not automatic,
No.
at least the present time. Now, I'm not sure how the new system's gonna work, but presently, we do look at that and make a determination whether or not they're there. And say, well,
Yeah.
give them a hearing.
And if a student, is there the opportunity for an applicant to apply electronically or remotely?
Oh, we'll get to that.
Yeah.
We'll get to that. Section E of the guidelines here, the informal conference is intended to be informative. And again, that's the same as it is today. And Section F, again, reinforces the current practice, which is it will be audio recorded or video recorded, and that the applicant is entitled to a copy of that audio recording. And in answer, Meredith, in answer to your question, Section G does provide that the applicants generally, if they're going to participate, they should appear in person. However, and this is something that's new, that at the discretion of the program manager for demonstrated good cause, an applicant may participate remotely via Skype or by other compatible means, because we do run into the situation at times where an applicant really wants to appear but can't for financial reasons, maybe they live out of state or whatever. So we want to make sure that we give those applicants the very best opportunity to present their case. So we haven't used this yet, but in due time, I think that we will, and it'll be an interesting experiment as to how that happens. But I'm sure we'll be able to do that. In Section F, this is where we determine under the pending system who will be allowed to participate. It's structured so that the program manager will be a consistent participant in the informal conferences, as will counsel for the moral character unit. At this time, it's David over there, David Lane. In addition to that, the panel will also be comprised of the investigator that's assigned to the case, the investigator that actually investigated and evaluated the case. That person will be part of the panel and part of the interview team. And we've also made it so that it will be limited to investigator 2s. Those are the more senior investigators. Investigator 1s are the less senior investigators. So we felt that to limit it to investigator 2s who are more seasoned with more experience would be the better route. In addition to that, this particular section also provides that although the moral character unit counsel should be present at all the informal conferences, there may be times when he can't be present, in which case other counsel in moral character could be appointed to serve on the panel in his absence with the approval of the director of the Office of Admissions. There are a few attorneys in the office other than David, myself included, and there are other attorneys that also could step in. The idea here being that there should be some counsel that is present at all of the informal conferences. We've found that to be useful. The section I sort of reinforces the fact that there could be people at the informal conference other than those who are actually asking the questions, in other words, observers. And for example, the Office of Chief Trial Counsel, a representative, as is true in the current system, are entitled to sit in and observe. Section J addresses whether or not an applicant may attend with counsel. She can. That is strictly up to her, and Section J outlines what counsel can and cannot do during the informal conference. Again, these procedures are in place currently, and so that they don't change under the new system. And the rest are just sort of scheduling. So those are sort of the highlights as far as how the informal conferences will be conducted by staff under the new system. Now, if the applicant receives an adverse determination from staff and wants to petition or wants for review of that determination, the applicant can in fact do that by petitioning the Committee of Bar Examiners. And there are procedures that will govern those types of requests, and these procedures were reviewed and approved by the Committee of Bar Examiners just recently. So, I'm sorry? Yes.
30 days.
Yes, as a matter of fact, thank you for that, because now that's a wonderful segue. Section A, do you want to have something to say, Jim?
Do you want to talk about what type of determinations might be made, or you want to do that some other time?
I think that maybe we should do that another time we go into sort of all the alternative routes that one can go. I think that's a real fruitful area for discussion.
Okay.
So,
Well, I think we did talk about that initially at the first meeting. We could review it again, though.
okay.
But before you move to the administrative review, can I ask a question about A?
Certainly.
Which I realize is the way it's always been. I just had a question. Is there ever a case where the program manager makes a determination that this person should not even be eligible for an informal conference? It's just an out and out no.
No.
You either get a yes, you're moving on, or you get an invitation for an administrative review.
That's correct.
Am I wrong?
No,
Well,
wait,
informal
hold-
conference.
An informal conference, that's what I meant. Right, I'm sorry. Yes. And nobody will, in other words, nobody will be denied without an opportunity to participate in an informal conference.
Great, thank you.
Okay, just wanted to make sure you knew that.
Yeah.
Yes, Judge?
I was gonna say, can we put that out there somewhere, so on the website, so everybody knows that that's the process? There's no, you have not passed and you don't get an informal learning opportunity?
Absolutely, sure.
I think it's
Clarify it.
helpful for
yeah,
transparency,
that-
for people to know that there's not a way for them to get denied without having any kind of ability to, or not even,
Yeah, no, it's a very good point, and I think that should be done.
thanks.
I
Absolutely.
think that actually speaks to my earlier question where I was asking about the percentage of applicants who disclose something. I think this number is more relevant, the number of applicants each year that goes to informal conference. I think that's more helpful.
Okay. So let's move on then to the guidelines.
I'm sorry, Meredith, did you have the answer to that number, though?
Well, we got an estimate for last year was about 250.
Yeah,
but it
that
would
was
be-
just sort of a broad, that's sort of the range around 250 a year.
Yeah,
Informal
I thought in
conferences.
2018 it was 180.
Yeah.
And right about that roughly in 2017, I think.
Yeah.
We can get those
Thank you.
numbers for
Yeah,
you,
that would
though.
be very helpful.
So now we can review the procedures governing informal conferences as they relate to petitions for review to the Committee of Bar Examiners. The applicant, Section A, states very clearly that a written request for administrative review by the CBE must be made within 30 days of the date of the notice of the State Bar's determination. And in Section B, we have, here's where you need to send your petition for review. And Section C describes what should be in your petition for review, including describing the applicant's relevant background, the moral character issues raised by staff, expressing the reasons why the determination by staff should be reviewed, and describing the applicant's rehabilitative efforts.
I think I'd like some real input from the school on C, because this is what the CBE has said we'd like to see, but what does the school feel like should be required of the applicant? So I'd like some input from you, not necessarily today, but at some point in time, about whether you think C's fair. Sorry, Mark, but I'm going to say that.
So Section E describes what the panel will consist of, and the panel by the CBE to review these petitions will consist of 2 members of the subcommittee or the Committee of Bar Examiners at large if members of this moral character subcommittee are unavailable. and one of the members of the panel will be a licensee of the state bar. When we refer to licensee, that means an attorney who's either active or inactive. So as long as there's an attorney, whether inactive or active, on that panel.
An example of that, I think, would be Your Honor, who I think aren't you currently deemed inactive, Your Honor, because you are a judge?
I am.
Yeah, so
Yeah.
you could be on the panel even, because you'd be
That's
licensed,
right.
but inactive.
That's
Okay.
right. And Section E also makes it very clear that the record that would be reviewed is a record that was developed by the Moral Character Unit, and in addition, any supplemental information that is provided by the applicant. The Section F provides that within 16 days of the request for review, the panel will review the record. And the panel may also request additional information from the Moral Character Unit, or they may request it from the applicant. And also, as it says here, generally, these determinations should be made on the record. However, this guideline provides that in exceptional circumstances, the panel, the review panel, can in fact ask for another informal conference if they feel that's necessary. So there is possibility that some applicants will in fact receive 2 informal conferences, one by staff and one by the Committee of Bar Examiners. The process then continues that, the panel, in Section G, it provides that the panel will present its findings and recommendation to the committee, and then the committee can adopt the findings and make take any other action it deems appropriate. And then after that, the applicant is notified within a set period of time, and in addition to that, you'll see in Section J, the applicant will have that opportunity, if the applicant disagrees with the outcome, to then proceed into the State Bar Court for formal determination and hearing. And then from there, the hearing department, review department, and then on to the California Supreme Court. So that is the proposed new process once the Supreme Court approves the admissions rules. The revised admission rules. Does anyone have any other questions?
For C, what do you imagine the length of that to be?
I'm sorry, Debbie?
For C, the applicant, what the applicant's required to send to the concise statement, what is concise? You can imagine some people sending you a C file worth of documents.
Yeah, and I think that, I mean, I know what you're thinking, that, for example, in appellate practice, for example, there's a set number of pages one can provide to the court unless there's a petition to go over, and get it. But we decided to just keep it as concise and hope that the applicants we'll just sort of see how it goes, I suppose,
Should they know that what they've already submitted as part of their initial application of all the evidence of rehabilitation that they might have already submitted, that would be forwarded and they don't need to replicate that?
Yeah, and I think what we could do, and that's
be explicit about that, just so that they don't feel like the onus to.
That's a very good point. I think where we could put that is in the if staff makes an adverse determination, and then in that notice of adverse determination, we will be outlining in that notice what their appeal rights or petition for review rights are. And I think what we could do within the context of that letter, emphasize that very point, which is that, here's, and in fact, I think what we could do is also attach a copy of these guidelines. Could probably do that as well, but that's a very good point.
I'm not sure whether this is the right time to raise it, but I'm going to talk about references. When are we going to talk about the importance of references in the moral application? I find them to be important. Is that something we're going to discuss now, later, not on the agenda at all?
I don't think we had it specifically as a topic. We could add it as a topic. I don't know if we can talk about it now since it's not on the agenda itself.
Yeah, good point.
So
Maybe during the discussion about rehabilitation, it potentially could come up then,
yeah, okay.
talking about applicants.
So an applicant who basically saying, I've approved, here's my reference from the victim or from my priest or from the local food bank or something of that nature. So I think that's important for you at some point in time to hear. I think, for me, those reference letters were very important. So can we put that maybe on the rehabilitation schedule?
Yeah.
Especially, we mentioned this, that we've gone out to do law school presentations and have heard from law schools who participate in the letter gathering process as well, too. Yeah, I probably shouldn't say too much because we just came back from that session. But yeah, the schools can participate in that process.
Okay, Mark, you done?
I'm done.
Okay. So that, I think, brings it back to me, and that is to talk about two things. When are we going to meet again, and where we go from here? So, if you look at the Moral Character Working Group multi-page document we got, you'll see that meeting 2, which was today, we talked about a number of areas that come up in informal conferences and moral character issues. Meeting 3 is the next set of things, which I believe Dave is going to be putting a presentation on the next meeting. Again, more areas that come up, just kind of, you know what's coming our way. Is there anything else at this stage someone feels that we're not covering or they want to talk about today, or we can kind of help prepare for the next meeting?
And I think just to add to that, on the agenda, just like how, for example, we had other topics like the number of denials and Michael gave his presentation, we'll have the topic of the law schools and their role in it as a separate topic of discussion.
So do we want to talk about proposed dates now, or do you want to have them get back to you on those proposed dates? The proposed dates were October 11th, which would be the first choice, and October 16th or 23rd would be the alternate choices. And we're talking about meeting in San Francisco. Again, we would meet it starting at 10:30 in the morning.
Yep, I think that schedule seems to work. And if you could just check your calendars and then let Ezra know if it's not today, that's fine. But the sooner we can get it scheduled, the better.
And again, you can appear by phone if need be, not video conferencing that I know of. We can appear by phone. But if you're going to appear by phone and you're not in a state bar office, there are certain disclosures. You have to put a sign on the door. Wherever you are is open to the public, so you can't do it in your house generally. But it can be available to appear by phone if you aren't here in person.
What were the potential dates again?
October 11th is the first choice. The 16th and the 23rd are the alternate choices.
Yes.
Yes, whatever, if you're not here.
And on that note, I just wanted to make a quick announcement that Dusty and Mark will both be retiring, so this will be their last meetings here with us. So if we can just say thank you to them for their participation.
It's really been a pleasure, and I will be staying in touch through the video conference, and watch it from home. But I know it's be hard to tear myself away from this particular area, which I really, really love. So good luck with with your future work.
So, if I can clarify a couple of things also. And I apologize, I left the room for an hour and a half. And obviously we were talking before I left about some of the additional information that would be helpful, the data for that we would be pulling in between meetings. Specifically, we were talking about with the adverse moral character determinations, coming up with sort of drill down as much as we can drill down to give you some understanding of the reasons that if these denials sort of fall into particular buckets, that would be sort of helpful for you to know. And I'm sure if there was any additional information that came up while I was out of the room, that Tara took that down. But I do want to make sure, and it's it's not apparent sort of from the breakdown of the topics of discussion, and it wouldn't be. I expect this group to be rolling up its sleeves pretty darn soon and really sort of helping develop what these guidelines are. And so I want to make sure that everyone in the room has an understanding of sort of how that process is going to evolve. And since we know that that's where we're heading, what other kind of information would you want us to provide to you to enable you to do that work? Because depending on where that falls on the sort of timeline, maybe some of it we would get for next meeting, and maybe some we'd be able to produce before the meeting after that. And I just want to sort of start thinking about the information, the data, the what we do, what other states do, any kind of information that would help you sort of roll up your sleeves, whether we're asking for applications from all the law schools because they all ask different questions. What is it that'll help you to help develop these guidelines and whatever kind of decision matrices or anything like that we ultimately put together? If you've got, yes, if there's anything on your mind now, then please say it. Otherwise, go ahead and direct that through, should it be Dave or Tara?
So can you send it to Ezra and I, and that would be great. That way we can compile them.
But if there's things that you can think of now, please let us know. We want to make sure that we give you the information that you need for you to effectively serve your role here on the working group.
Can I ask you, legal counsel over here, before you depart? Last meeting, she warned us about communicating.
And I'd like to know the guidelines, because I really would like to talk to my fellow members and talk about some things, but what exactly are the guidelines that you think would be out of line for us to do?
Right, you should not do that. All of our discussions should be open to the public so the public can participate and have transparency about how decisions and thoughts are flowing. So for that reason, you should not be emailing amongst yourselves. And when we're not in an open meeting, you shouldn't be discussing the topics and ideas that are before this working group.
Would it be appropriate if I send a request, for instance, or a issue to Tara or Dave to include them as copy, so they get my information to them?
No, it would not be. You can send something to staff. Staff can send something to everybody on the committee, but as a member, you should not be communicating together because that becomes a discussion among the members.
But if I do it and then staff sends it out to everybody, it's okay, as long as I'm not doing it.
Yes.
Because I would want them to start thinking about it.
So, it sounds like you can accomplish the same thing.
Yeah, as long as Ezra's really good at getting that word out, because otherwise how are we gonna know what we're all thinking?
Yeah, and we're just really cautious on, we would BCC all of the members so nobody accidentally hits reply all. That's one of the reasons that we like to control the communication is because if you start hitting reply all, that's when you end up effectively having a meeting by email and violating our Open Meeting Act rules. And so that's why we would like you to send it through us so we can make sure that we have the appropriate protocols in place so you all aren't communicating with one another over email.
And thank you for asking though, because it's important.
That's one of the good guidance.
Yeah.
So
Sorry,
I've got a
Debbie.
question. Donna, when you talked about us rolling up our sleeves and getting involved in the work that needs to be done, could you describe to us what the format of that would be? In other words, will it be an opportunity for us to just sit and quickly exchange thoughts back and forth as a working group that's really going head on with each other, or how will it be done?
So there are a couple of options, and I'll sort of generally talk about some ways that it could happen. And Tara and David may have some thoughts on sort of what they have envisioned for this group, right? So one of the things that we can do is we can, identify, there's nothing that prevents us from posting an agenda super early and saying that, topic A on the agenda is we're going to review guidelines or come up with an outline. Let's come up with an outline for guidelines on how you deal with X, whatever X is. And so you'll all have thought about that ahead of time, and you're going to come prepared to fill in that outline. And we'll be, projecting on the screen as we're talking about it and debating it back and forth. It may be that instead of that, and then turning that, we would then turn that into precise language in between meetings. Staff would do that, and then we'd bring it back to you as precise language, the next meeting. Another way to do it is that we would sort of chunk out the guidelines into sort of digestible, coherent pieces, and we'd say, okay, Tara's going to take the lead on drafting the part of the guidelines from the staff perspective, drafting the part of the guidelines about how we deal with felony convictions. Debbie, will you work with Tara on that? And so Debbie and Tara offline in between meetings will be working on those guidelines, and then we'll be able to present something to all of you at the next meeting. Those are a couple of the ways that it can happen, because sort of full-on drafting in a room, difficult. But sort of developing outlines and getting your buy-in on an outline and having us draft it is a way to do it, or sort of working with key people who have expertise in particular topics and having you all sort of present those segments at subsequent meetings is a way to do it too. Tara and David, we haven't talked about what your plan is for how we're going to sort of roll up our sleeves and get that done.
Well, I think our starting point, so one of the main purposes was trying to create this transparency and the understanding of what it is we're actually looking at. So that's why we kept talking about these revised statement and guidelines. Rather than having this kind of vague moral character statement and the factors online, is creating one cohesive document which more so outlines like what we're looking at, what factors we'll consider. So I think we started to do that by having the proposed language and the proposed mission statement. So I know you did ask for a little bit more time. So in between this meeting and the next, if you have the opportunity to review those sections and let us know if you have any feedback, and then we can always compile that and bring it back at the next meeting as well. So that's just a starting point. And so our idea, I think, as Donna was saying, was going topic by topic to start with, and then we can also start doing some of the other portions of the statements and guidelines, like what the procedures are.
It's taking many meetings just to get me up to date on all the things you do, because I don't know the insides, now I'm learning. So I don't think I'm going to be ready to participate in drafting until I've been through this whole process of these 5 full meetings where I learn everything. Then I think I'll know enough to be effective.
But David, or Tara, there was language in the PowerPoint that had, and I'm not saying I want to spoon feed, but I think it presents some ideas. There was language drafted in the PowerPoint on each of these topics, suggested language on these topics, but there definitely will be more or additions, and just to get your mind around some of the areas that we want to speak to, because I think the idea is to create, to use the values that we discussed here. We now will add the diversity component, but using those guidelines as to how to create more transparency in these guidelines, or a statement, like a mission statement for moral character. So I think the language, and everybody got a copy of that PowerPoint, will help guide some of that, so that you don't feel like you're learning it and doing it at the same time. I think that'll help jog a little bit.
Yeah, and we'll tweak those, that language based on people's feedback today as well.
I have a question. It was on. So when we're talking about the informal conferences, is there a standard of review that's applied to that? And is that something that can be included on the website for students, or included in the guidelines for individuals to know what the standard is? Is it a preponderance of the evidence? Is it something else?
I think I'm going to punt this to General Counsel, because this it was a question that was raised when we were considering the guidelines for CBE review of petitions for review. So, Caroline, you want to weigh in on this?
So I looked into this question, and it's basically our determination that no standard of review need be applied, because the Committee of Bar Examiners is the administrative decision maker for purposes of moral character determinations. So the first appellate level review happens at the State Bar Court, and the standard of review that they apply is de novo. At the CBE level, the record remains open throughout all of the various internal review processes, so it's not because the record's still open, they can request additional information, and there's no point at which the record closes. There's no actual appellate level review. Does that make sense? No. Oh. Is there something else?
What's the review
I
in,
guess-
When we're looking at the evidence, is it just, so preponderance is, 51%, or is the standard of level of review gonna be, I can't believe it would be beyond a reasonable doubt? Is it strict liability? Is it, there's,
Right, what you're
There's-
talking about is what does the applicant have to show
Exactly.
to establish the requisite moral character?
exactly.
I
The
believe
burden
it's a
of proof.
preponderance of the evidence, isn't it, Mark? Isn't that what the case law says?
What's
Well,
gonna
you're
be
talking about
pres-
They
so
have
burden
the
of
initial
proof.
showing.
Right, so what is there, so obviously there's, at some point it's gonna have to shift to the committee to make a determination, and when they're evaluating it, is it gonna be a preponderance? My gut feel is that's what is probably happening, but whatever the standard is, I feel like that should be disclosed to the student at the beginning, so they know what burden of proof they need to establish when they're going through the process. Whatever that standard is.
So, and that is a slightly different question than what standard would be applied on, or would be applied during the appeal review. So you're
Yeah, I'm-
talking about
I'm talking
what's the burden of proof? What is the
Right,
burden of
what
proof?
do they have to establish? They're brought in for an informal conference, we're inviting them in, I know it's totally voluntary, but they should know what it is that's being expected of them, right? So, what do they have to do to convince, whatever the question is, how many drinks did you have that night? What is the burden of proof that they need to know to establish that they have overcome the presumption or, whatever is being brought to question?
well, my personal experience is when I look at an applicant and I make a recommendation, and what happens now currently is, after the informal conference is over, the 2 or 3 members who are part of the committee sit down and kind of talk about the individual and kind of decide what's appropriate and listen to each other and then make a recommendation eventually to the full committee. But I personally kind of say, if I had this record in front of me, do I believe it's defensible in the state bar court? So I use the preponderance of evidence. Would we be successful in state bar court to defend our denial if we deny this person? So that's just what I do. I can't speak to anybody else.
Well, and so everyone should be doing the same thing. So if that's what you do, then everyone should be applying that same standard so that there's some continuity of review. Whatever that is, I feel like it needs to be, and that's my gut feel, is that that's what is happening. So maybe we put that in writing to let people know that's the standard of review.
I think general counsel's office, perhaps that's something for general counsel to take a look at it, because it really is a question as to, the creating and implementing a standard of review of that nature, and whether it is in conflict with any of the Supreme Court rules with respect to how we conduct these kind of evaluations. So, it may be, it's an issue to look at. Yeah, it makes sense.
Yeah, I think the point sort of behind that, Judge, is that we say in our documents that the applicant has the burden of proving that they have the requisite moral character. So what does that mean, right? So if for whatever reason we can't use a sort of clear and concise statement of what that burden is, then certainly some examples of how to meet that burden, what would and what would not meet that burden, would seem to be appropriate. It's difficult to tell somebody they've got a burden and not.
You're
tell
right,
them what that
so
means.
yeah, exactly. You can't just say preponderance, clear and convincing, strict liability, you're absolutely right. So some examples, just like for the civil, or list any civil procedures you've been through. You list divorce as one of them because it may not jump out at people. So same thing, just try to make it easier for individuals to understand what the process is.
Would it have to be a burden of proof that would match what's done in court, or could it be something stated differently? Maybe more convincing than not, for instance, could be prudence, which I guess is used at times in legal procedures, but not necessarily in the criminal courts that the judge is involved with. But I think there's got to be something that guides people as to what it is what standard they have to come up to be able to make
It might even be interesting to see whether other jurisdictions in this area have, you know, their own standards and what they do. That might help inform this a bit.
Great idea.
So why don't we put this on our to-do list? Caroline, if you'll sort of take that for, ideally for our next meeting, we can come back and report back to you on what it is currently, what other jurisdictions do. If what it is currently is, you know, what binds what it is currently, and what freedom do we have to change that, and we can talk about all of that at the next meeting.
Separately, is it possible to put that on the CBE agenda? Can we put it on the Committee of Bar Examiners agenda for the next meeting? I'm just something that I think would be appropriate for our committee to talk about. The standard, yeah. Maybe put in our goals or something. Okay. All right. I should tell you now, our goals. Thank you, everybody. Oh, yes, please. I don't want to cut anybody short.
No, just, so our mandate is to develop guidelines. Does that include making recommendations on the kind of training staff should be getting in order to implement these guidelines in a consistent and fair and, not that I don't think that either of you are gonna do this, not in it, but you may not be here forever. I'm just wondering, like, how far out does that mandate extend? And should we be thinking about also not just developing the guidelines, but how they actually get implemented?
And include investigators on their staff.
Yeah, it's, you know, in fact, you know, and let me just say that we do have training calendared for staff as we transition into the new process. I think we're calendaring it on the 16th or 13th or the 16th of September, one of those. So we have thought about the fact that, yes, staff needs to be trained with respect to how to properly conduct, you know, these informal conferences. I think that's what you're talking about, Debbie. Yeah, so we have been thinking about, we do have a training calendar.
Well, and just to be clear too, the CBE has been carrying out the informal conferences, and there's ongoing training that we
That's
provide
right.
the CBE members as well, as part of moral character, or whether it's in testing accommodations, whatever the arena is, that we have ongoing training, so that's.
Yeah, but I think, this came up last year when we held a roundtable at Stanford on the issue, is that there was some question about what, getting into more specialized training that might be necessary that currently wasn't being done at the state bar level. Like things like on technical issues related to like desistance or implicit bias or like whatever it is, that some of that may be getting done, some might not be. I'm just wondering, it's really great to develop standards, but I think we all know that like, and they're only as good as how well they're implemented.
Yeah,
And
I think
that requires like lots of training
No,
and thinking
absolutely,
about it in the context of new guidelines in a different way.
And I think that's very valid, and I think that kind of training would be valuable to staff.
So yes,
So yes.
yes, implementation of those guidelines. That's within your scope.
That could be added as a topic at some point.
Larry?
Moral character switchover is happening as soon as the Supreme Court approves it, correct? So that could be next week, because they're meeting like in a week or something, right?
We do still have a couple more informal conferences that will be scheduled in October, I think very early, or excuse me, September, very early October with the Committee of Bar Examiners. So this next round, just because based on the committee's last request to have some of the others attend, even if it's approved before then.
Those will pretty much be it.
If it is approved, yeah.
So you don't anticipate this, being approved by the Supreme Court by October?
No, they might be.
Right.
I mean, today, there's administrative conference today. Could be approved today, could be approved next month. We're not going to, we don't have a secret hotline. So,
But either way, the committee members are going to conduct the October informal. Yeah.
Okay, anything more for today? Okay, I'm lifting to Burbank Airport. I believe we'll get at least one person who's gonna lift with me. Anybody else is going to Burbank Airport? And we'll see you all in a month or two.
Thank you.